set.
Okay, I'm sorry. I
All
thought
right.
we were off.
This is 2501-1196. Plaintiff is Midland Credit Management versus Christina Snowden. Counsel, can I get your appearance?
Why am I on my phone? I don't want to be on my phone.
All right. Counsel, can I get your appearance on this, Mr. Monroe?
I'm sorry, Judge, I was muted. I'm David R. Monroe, P18081, Appearance Counsel for Midland Funding.
All right, Ms. Snowden, can you tell me your first and last name?
Christina Snowden.
All right, so this is our first pre-trial in court, and both parties are present. Would the two of you like a breakout room to discuss this?
That'll be fine, Your Honor.
Oh, what's a breakout? Yeah, I don't know what that is.
Yeah, Ms. Snowden, I'm going to put you in another room where you two can have a private conversation about this, okay?
Oh, okay.
And see if you can come to a resolution or just have initial discussions, and then when you're done, you'll come back out and we'll discuss it further, okay?
Okay.
All right, we'll see you in just a few.
Okay.
So you'll see something asking you to join a breakout room.
I see it.
I don't have. All right, Mr. Williamson, Mr. Kirschneider, are you ready?
Yes, ma'am.
Okay. Counsel, Mr. Williamson, can you turn your camera on, please?
Just a- You see me?
I cannot. Can you see me?
Yes, ma'am.
Okay. All right, Mr. Williamson, Mr. Kirschneider, did I get your appearance?
Michael Kirschenheiter for the plaintiff, P75722.
Thank you. Mr. Williamson, can you tell me your first and last name?
John Williamson.
All right, so it's our first pre-trial in this matter. I did see a complaint was filed, an answer was filed, and we also have a motion for summary disposition of. Have the two of you had any conversations?
Judge,
No, ma'am.
no, we have not spoken. I'm happy to speak with Mr. Williamson. He indicated a fraud situation. We received his fraud packet. My client did have a chance to review it. Happy to discuss that directly with him, but they're not, they're not accepting it as a fraud claim. So we do need to move forward with the case, but I'm happy to speak with him.
All right, so Mr. Williamson, they've investigated your allegation of fraud. And I'm guessing that they indicated or found that it wasn't fruitful.
Well, he sent me a packet of papers, and I seen all kinds of stuff in there. Other than I don't see where my signature. I haven't seen my signature yet, or the application for that credit or whatever it is. They're just showing me that it was charged a bunch of jury and medical, which I don't understand that either.
All jewelry and medical.
Yeah, that's what the paperwork they sent me says. Jury and medical. It's out of state, and
Oh, Jewel.
I haven't seen anything. So I see who they bought it from and charges. That's about it. I don't know who they are. I haven't left the state of Michigan. I haven't left the state of Michigan in 25 years, and I don't know what state that was in.
All the statements were sent to his current address, Judge. There are multiple payments on those statements we provided on our motion for summary.
Were the purchases all made out of state?
I'm looking. Judge, I don't see any purchases on the statements we provided, just the payments.
Right.
So
So, Mr. Williamson, the issue is these bills came to your house on West Point and you paid on them.
I don't know where it came out of my account. I know my account's been hit about 3 or 4 times. My wife's,
Well, I mean, it doesn't work like that, Mr. Williamson. The idea that somebody would come to your house, steal your identity, then come to your house and steal your mail, and then get into your bank account and make payments on a debt on your behalf, I mean, that doesn't make sense to me.
none of it's making sense to me. I haven't left this state in
Well,
25
no,
years.
none of it, there's no indication that these purchases were made out of state.
Bank or credit police, they told me it was, I forgot what state it was. I have to look through the paperwork. But
I mean,
it's
because
not-
just the company is out of
Right.
state
Right.
doesn't mean, like, the credit company is out of state, doesn't mean that the purchases were made out of state.
Yeah, all I wanted to see is like the application with my signature on it. Then I haven't seen, they haven't showed me anything. I've sent them everything they asked me for. I haven't seen anything proving to me that's what it is. I sent them a
The
copy of
account
my driver's
statement,
license. Pardon?
Mr. Williamson, I see that payments were made. I mean, it's sent to your house in 2021, you were making payments on this debt.
I don't recall anything on it.
Well, I mean, I'm looking at it. It's in the paperwork that you received. I mean, I'm looking at it, and it was attached to the original paperwork that was filed in this case.
But it's not showing me where, who they are or where my signature is anywhere. I haven't seen anything like that.
I'm looking at it. It was on the complaint.
A copy of my signature?
No, a copy of you making payments on it when the bill was sent to your house.
I do not recall making any payments to, like I said, the only name I got is what they sent me. I don't know who the hell they are. I'm sorry. I don't know who they are.
All right, Mr. Williamson.
I mean, that's all I want to know is who they are and see my signature. And, the application there with my signature on it, and I'd be more than happy to deal with this.
Well, you made payments on it. Why would you make payments on a bill that you didn't know?
I don't
That went
recall
to your
making.
house,
I don't recall making any payments.
but it shows that you did. Mr. Williamson, it shows that you made payments.
From my checking account.
Payments were made from your address to bills that were sent to your address on this debt.
I still don't recall making any payments.
Okay, well, you did. And there's documentation to support that.
What bank?
What bank are we talking about?
Mr. Williamson, you made payments on this debt. Your payments were received. Mr. Kirschneider, do you have information about where that, was it a check? Was it a debit card? Do you have any of that?
I don't, Judge. Let me take a look. No, Judge. All I have is just the information on the statement indicating the payments were received.
I mean, I don't know how we get around that. It's a credit card that was taken out of your name. Bills from the credit card were sent to your home. Payments were made on that credit card that was on that bill that was sent to your home. And now you claim the credit card's not yours. And that just doesn't make any sense to this court. It's an account stated and pursuant to MCR 2.116, parent C, parent 10. There is no genuine issue of material fact, and the moving party is entitled to judgment as a matter of law. There's no question as to the amount of damages. It's stated, the billing shows what it was, and I'm granting the motion for summary disposition.
I'll file an order, Judge.
Thank you.
Have a great day.
What was that?
All right. I'm granting his motion and ruling against you, sir. You owe that money.
All I asked for was to see my signatures, all I needed.
I know, but sir, you paid the bills. You've been paying on it. And it doesn't make any sense to me that you now want to claim that's not your credit card. And it's an account stated, and for that reason, I'm granting plaintiff's motion. And we're all set.
Thanks, Judge.
I wanted to see
Thank
the
you.
application, ain't that the law? They cut me off.
Why is my video?
All right. I have a few other people here. I don't think I have all parties on anything. Or are we back with Miss Snowden?
Yes, Miss Snowden's back.
All right.
Yes,
Were
we
the
are
two
back.
of you,
5T644775. Your name?
Nicole Shinsky.
So we adjourned this from the power outage, right? Yeah. All right, so you have the right to you're charged with failure to pay $213. If I find you didn't pay and your failure to pay was not without your fault, you could be incarcerated for 22 days. You can satisfy that in full by payment, full by serving the jail term, or in part by payment and in part by serving the jail term. Do you understand that?
Yes.
You have the right to a hearing. Did you sign this advice of rights form here today?
Yes.
Did you read it and understand it?
Yes.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes.
You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
No.
To the charge you failed to pay $213, how do you plead?
Guilty.
Did you fail to pay?
Yes.
You have it now?
I do not. I'll have it tomorrow.
You gotta get a hold of the court though, man. This was from February, right?
I understand both my parents passed away right after each other, and I just haven't been thinking straight.
Oh, geez, I'm sorry. You can pay in full tomorrow?
Yes, I can.
You pay $195 by tomorrow. I'll waive the balance, okay?
Okay, thank you.
All right, have a good day.
Thank you, sir.
Eric Christian Schmidt, 1-8F-228-228-055. Bradley Noble, you can have a seat up at the table here. Yeah. Where's Eric Schmidt? Is he out there, Lisa?
Yes, it'll be just a second. The breakout rooms are acting up again.
Okay.
There he goes.
Bradley, good morning, Mr. Bogard, your name?
Good morning, Your Honor. David Bogart appearing on behalf of Mr. Eric Schmidt, who is present and seated to my right. Mr. Schmidt, please tell the court your full name.
Eric Christian Schmidt.
All right, so you pre-tried this. This could be a plea to disturb the peace, the public intox to be dismissed, true?
That's correct, Your Honor.
Is that what you want to do, sir?
Yes.
Plead guilty here. The possible penalties are up to 500 fines, 90 days jail. Costs are all those. Do you understand that?
Yes.
And you are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to a trial by court or jury. At a trial, you have the right to remain silent, question their witnesses, bring in your own, use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you're giving up all those rights and there will not be a trial. Do you understand that?
Yes.
You still wish to plead guilty here?
Yes.
Charged disturbing the peace. How do you plead?
Guilty.
Were you on July 27 of 2018 on Telegraph, hit or near 231 Telegraph in Flat Rock?
Yes.
What did you do?
I was just being loud and obnoxious.
Were you drunk?
Yes.
Are you on probation or parole?
No.
Anybody force you to plead guilty?
No.
All right. John, call over to Mr. Cade, see if he has a police report on this.
Okay.
I don't see it. Are you aware that you have a warrant out of the 27th District Court?
Yes, Your Honor. Just for the court's edification, we're aware that he's got a warrant out for non-payment over there. We're also due back in your court again, just so this court's aware of things. Next week, it's Foley Carter for another 2018 case of DWLS. Your Honor, I got involved because I was working on getting a driver's license restoration back, and I had explained to Mr. Schmidt that all of these outstanding issues need to be cleared up. So that's just, you needed to know all of those things. That we'll be back next week. And Your Honor, I know you didn't ask yet, but I would ask for today for an immediate sentencing and for that, if the court would allow that.
Oh, I mean, accept a plea. You need to tell me why he doesn't think he has to show up in court. Why doesn't he show up in court?
I asked him that question, and I think Mr. Schmidt could go ahead and probably explain it. Just tell the court, just like you told me, this was 7 years ago.
Your Honor, it was just a hectic time in my life. I wasn't living right. And, that's not me anymore. I'm just trying to clear up the mess of my life, man, and get things back on track.
Quite frankly, Your Honor, too much drugs and alcohol at that time. And he has been sober and clean now.
Anything else anybody wants to say before I sentence him?
Your Honor, as I said, Mr. Schmidt is sober and clean now. He has been going to AA. I am his attorney on all of these cases. We are due back here next week again. Judge, we just asked the court to sentence appropriately and what the court believes is appropriate at this time. We are trying to work through a driver's appeal, and we do have to clear up the Wyandotte costs. Those are $594 that are due, and he's aware of that. So
Anything?
thank you, Judge.
Thanks. Anything else, Mr. Schmidt?
No, Your Honor.
500 fines, 75 costs, 75 victims' rights fee, $50 justice assessment, 700 or 90 days. Can you pay that now?
Yes.
All right, you can go right on 33court.com with this case number and take care of it. Good luck.
Thank you. I'll have him do that today, Your Honor, right now.
Thank you.
Thanks, Judge. You and your staff have a good day, and I'll see you next week.
You too. Thanks. Bradley Eugene Noble. Come on up to the podium, 24R50563.
He wasn't in the office,
Your name?
Brad Noble.
All right, you have a dog running at large case. That's a misdemeanor. And you have failures to pay on 2 civil infractions, $213. If I find you didn't pay, you could have paid, failure to pay was not without your fault, you could be incarcerated. You could get 22 days on each of these. Do you understand that?
Yeah.
On the dog at large, you could get incarcerated. You could be incarcerated. I'm just telling you the maximums.
Okay.
Up to 500 fines, 90 days jail costs are all those. You understand that?
Yeah.
Did you get an advice of rights form today?
He was unable to read it, Your Honor.
Okay, you're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You're presumed innocent. You have the right to a lawyer. I'll be happy to give you a lawyer right now. Would you like a lawyer?
I don't think so.
All right, you have the right to a trial by court or jury at a trial. You have the right to remain silent, right to testify if you so choose, right to a jury trial, right to bring in your own witnesses, right to use the subpoena powers of the court to bring in those witnesses, right to testify, as I said, or remain silent. If you remain silent, that silence would not be held against you. If you plead guilty, you're waiving all those rights. You're waiving the presumption of innocence. You're waiving the requirement that they prove you guilty beyond a reasonable doubt. Do you understand all that?
Okay.
You still wish to waive your right to a lawyer?
Yeah.
I'll enter a not guilty plea. Do you, what kind of dog is that?
So, Reese Mountain Dog.
Do you live in a, Lafleur, that's a house, right?
Yes.
Do you own the house?
Yes.
All right, $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. You're to keep the dog in a fenced-in yard, in your house, or on a leash. Do you understand that?
Yeah.
I'm entering not guilty pleas for you on these noxious weed charges. This is for failure to pay on both of these.
Okay.
You owe $213 on each. Do you understand that?
Yeah, can you remind me about these weed things?
I mean, all I can tell you is duty to cut, destroy, and remove grass and weeds, it says on one on May 14th of 24, and on the other one, weeds in front yard in excess of 12 inches, measured at nearly 24 inches tall, unsightly weeds in backyard, not measured, photographed, and uploaded to lens lock, issued on May 14, 24.
Yeah, I didn't know about those. But I guess you put not guilty, so.
Well, I'm entering a not guilty on failure to pay. You've already been found responsible. You didn't show up in a default judgment.
Because I didn't know about it.
I mean, you can fill out a motion, but he says he served a copy on you on May 14 of 24 on the one, and on July 15 of 24 on the other one. The officer did. So you owe $416 on those two, and we have this misdemeanor. I'm sending you over to Rockwood prosecutor to talk to him about both of those. Okay?
All right.
And then you'll come back in front of me either way. Any questions?
No.
All right, best of luck. Kevin Shane Tishkoff, 25F244076. Good morning, Mr. Osmond.
Morning, Your Honor. Jeff Osmond on behalf of Kevin Tishkoff.
All right. What in the world was he doing?
A moment of stupidity.
Wheelies on motorcycle. These guys driving those motorcycles, I see them driving up north and back, and I'm telling you.
I know. No,
I
I
had a guy, right? Where was I? Let me think. Yeah, I was driving on 4th Street to work a 3 days ago, I guess. I think it was Monday. Somebody decided he was going to pass the car that he was following in the left lane by driving in between that car and my car that was in the right lane. I mean, and he wasn't going slow, and I'm thinking, geez, you're taking your life in your own hands. Anyway, you worked with the prosecutor. This will be a plea to impeding. The cure was to be dismissed. True?
Yes, Your Honor.
He's recommending fines and costs of $350. You guys agreed on?
Yes, sir.
Charge impeding traffic, responsible or not responsible?
Responsible.
All right, I'll accept the plea. $350. I'll give him till July 3rd. Is that going to be enough time?
That should be fine. Thank you very much.
Have a great day. Thanks a lot. Jenkins, Martiano, Rashawn Jenkins, 25F244158, A and B. Stephen Singleton, can I have a seat up at the table here? Your name?
Martiano Jenkins.
You're charged with unlicensed, driving while unlicensed and disobey a stop sign or a traffic signal, rather. You have the right to a lawyer on these. If you want one, I'll give you one. Do you want a lawyer?
No, Your Honor.
It is alleged that on June 8 of 25 at 3:43 PM that you were operating a motor vehicle on Breland near Hall and Flat Rock. They think you were unlicensed or driving without a cycle endorsement. That is a misdemeanor punishable by up to 500 fines, 90 days jail costs, or all those. Do you understand that?
Yes, Your Honor.
You also have a civil infraction charge, disobey a traffic control device. That's a 3-point civil infraction. Do you understand that?
Yes, Your Honor.
Did you sign the advice of rights and read and understand the rights?
Yes, Your Honor.
If you plead guilty, you'll be giving up all those rights and there will not be a hearing or a trial. Do you understand that?
Yes, Your Honor.
All right, you still wish to waive your right to a lawyer?
Yes.
I'm entering a not guilty plea, $500 personal bond. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed. We're going to take this file over to the prosecutor. You go talk to him. Either way, you're coming back in front of me today.
Okay.
Do you understand that?
Yes, Your Honor.
All right, any questions?
No, Your Honor.
Thanks.
Thank you.
Singleton, Stephen Singleton, 25W37520. Your name, sir?
Steve Singleton.
Mr. Singleton, 377. This is a show cause. Do you have all that money to pay?
No, I've been making payments, Your Honor. I had you signal a $50 payment per month.
No. Oh, okay, beginning March 7th?
Yeah, March 7th, yeah, so I understand this. I've been making my payments.
Well, I told you to pay $40 on February 19th, right?
Mhm.
And then I told you 50 a month starting March 7th,
Mhm.
right?
Yes, that's correct.
And you didn't pay anything until June 6th, right?
Right, that's correct. I gave her $100 on June 6th.
Well, that wouldn't be enough. You owed for March, you owed for April, you owed for May, and you owed for June.
Oh, okay.
So you're $100 light.
Yes, yes.
You went in March, April, May and didn't pay anything.
Oh, okay.
Remember when I told you to come talk to me if you had a problem?
Yes.
Why didn't you do that?
I can get back on that payment program. That was not.
Listen, Mr. Singleton,
Yes.
we're easy to deal with here. I'd like to think we're easy to deal with here.
I know.
But the staff has easier, more, they have better things to do than issue show causes and chase people around. So when I told you you needed to come talk to me, I still don't understand why you didn't come talk to me when you skipped 3 months worth of payments. Why'd you do that?
Oh,
Well, I don't either. Do you work?
no, I get on Social Security disability.
Okay. All right. All right, I'm gonna do this for you. I'm gonna dismiss the show cause. You pay 50 per month.
Okay.
I'm gonna start this beginning July the 7th.
The 7th.
Is that early?
July 7th.
July 7th.
You make it August 2nd.
You don't wanna pay in July either?
Well, I'm trying to give you some of the, like I said, I'm trying to give you something that I don't get you nothing, then I will be back in the same situation. But I know I have something in August.
I'll set it August 7th
Okay, thank you, that's fine.
and the 7th of every month.
The 7th,
What are you gonna do if you don't have the money on August
I'll
7th?
come see you.
Or September 7th?
I'll come see you.
Or October 7th?
Come see you.
Good enough. I'll dismiss the show cause, Lisa. I'll set them back up on the payment plan. 50 per month beginning August 7th, okay?
Uh-huh,
Good luck.
thank you.
Just come talk to me next time.
I will, sir. Have a good day.
You too. Brittany, Rochelle, Chapala Tweed. Your name?
Your Honor, yes.
Good morning.
Morning.
Your name?
Brittany Chapala. The big long funky name.
The big long what?
Big long funky name.
Funky name? So it's Brittany Rochelle Chapala Tweed. That's a nice name.
Oh,
All right, so you have a drive while license expired.
yes.
And you also, that's the only case you have. I'll be happy to give you a lawyer right now. Would you like a lawyer?
So here's, can I say, Your Honor? So I had a really good experience. I did have you guys look before.
You were in court before?
Yeah, I was. I had a really good experience with you. Maybe I'm not supposed to say that, but you guys, you know, the interaction I had with the officer and everything was good. Where I'm at right now, I'm like, I don't like to say it, but the officer that pulled me over gave me an expired, what is it, license?
Right.
And, he did give me grace on that. So if I plead,
Do you have a new license now? Did you get your license renewed?
yeah, I did. My trans was going on my other car, or on my car.
All right, just hang on a second. Let me tell you what you can do. I can either give you a lawyer, or I can go ahead and arraign you on this charge and let you go talk to the prosecutor. He's gonna be reasonable with you.
Yeah, because I don't wanna, combat against anything, the officer, like I said, it was really good interaction and all that, and he cut me a big break.
Why'd he cut you a big break? Let me see.
Well, I would say so, because. when I-
Defective equipment, no insurance, you gotta have insurance.
Yeah. Well, that's the thing, that's where I was getting at, when I kind of stumbled over my words, it's a little hard to talk about. So I had you guys before since my accident happened, and last time you guys gave me grace as well. I really appreciate that, because I have compression disc, and I'm hairline being paralyzed from my neck down.
Oh, no.
At 33, yeah. So, it's just I'm trying to take a cheaper revenue, you know, but as soon as I get everything good.
Let me arraign you.
Uh,
Listen, let me arraign you. And then you go talk to the prosecutor. Is that okay?
yeah, and I didn't know that before.
Why?
Since-
This is not the end of the world. This is an
Yeah.
expired license. Nobody thinks you murdered anybody.
I
Just
know I
relax.
appreciate it. And I don't want to be pulled over, you know, but I haven't dealt with it. But I'm gonna be honest, I still have to communicate with my kids, so hopefully, you know, I don't see you again, but, you know, I still have an obligation to them. So I still gotta, you know, things like that.
But you got a valid license now, right?
Yes.
Do you have insurance?
No, my car is actually down.
How'd you get here today?
I got, dropped off across the street.
Why'd they drop you off across the street? You didn't drive here, did you? You didn't drive here. I know you wouldn't have driven here if you didn't have insurance. Listen, let's not make this worse. I'm gonna go ahead and arraign you.
But everything's best.
If you want a lawyer, I'll give you a lawyer. If you don't, I'm gonna go ahead and arraign you and I'm gonna send you to the prosecutor.
Because if it's easier to plead guilty.
No. Let me just arraign you. I'll send you the prosecutor. He's a reasonable person. He'll be fair with you, okay? So they think on June 10th of 25 that you had an expired license while you're operating a motor vehicle in Flat Rock on Telegraph near Gibraltar. That is a misdemeanor. It's punishable by up to 100 fines, 90 days jail, costs, or all those in 2 points. Do you understand that?
Yes, sir.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights. There will not be a trial then. Do you understand that?
Yes.
Okay. If you still wish to waive your right to a lawyer, tell me. I'll enter a not guilty plea and I'll let you go talk to Mr. Caylor. Is that what you want to do?
Yeah.
Okay. Where do you work at, ma'am?
I don't work, I'm trying to get my social security book because I need to keep telling me I'm okay. So
You mean
I've
Social
gotten
Security?
denied, I've gotten denied a couple of times, but,
Are you married?
I have three kids, but my kids are older.
How old are they?
11, 12, and she's about to be.
Okay, not over
And then
18.
15, no, they're not over 18.
Are you collecting child support?
I get like $25 a month, so they don't really consider it.
$25 a month. Was it the same father of all three children?
My girls have the same dad, but my son's dad, it's just him. So there's some
Do these guys not work?
So I've done custody with my son's dad. I'll tell you what, you know, when you're young and you have kids, it really, you don't think about how important it is. Like, we have kids, we don't really think that far in the future, you know, and that's just life. And then my girl's dad is never, I think he lives like 10 minutes down the street.
He's gonna regret that someday. You go talk to
So that's all
Mr.
we need. I'm trying to do it.
All right, just relax. You go talk to Mr. Cayley here.
All right, I'm gonna.
Roger, take this file. This young lady has 3 kids, deadbeat fathers. They're not around. One's paying $25 a month. She doesn't work. She's almost.
And I know everyone has.
Go talk to him. Relax. Take a deep breath. Go talk to Mr. Cayley. He's very fair.
Well, thank you guys for always being fair, though. I appreciate it.
All right. Just keep smiling. Life will get better if you just take one day at a time.
Thank you.
Good luck.
Thank you.
And you're coming back in front of me either way, okay?
Okay, sounds good.
Jason Henry Herndon, 25F244.
Oh, I'm sorry.
25F244141. Your name?
Jason Henry.
You're charged with driving while suspended. You have the right to a lawyer. If you want, I'll give you one now.
No, Your Honor.
So you waive it?
Yes, Your Honor.
On June 9th, 25, the police think you were operating a motor vehicle in the city of Flat Rock, County of Wayne, and that you were driving with a suspended license on Gibraltar near Telegraph at 8:08 p.m. with a suspended license. That is a misdemeanor punishable by up to 500 fines, 93 days jail costs, or all those 2 points. Do you understand that?
Yes, Your Honor.
Did you sign, read, and understand the advice of rights?
Yes, Your Honor.
If you plead guilty, you will be giving up all those rights, and there will not be a trial of any kind. Do you understand that?
Yes, Your Honor.
You still wish to waive your right to a lawyer?
Yes, Your
I'm
Honor.
going to enter a not guilty plea, $500 personal bond. You cannot leave the state without the consent of the court or violate a law. You must appear in court as directed. We're going to take this over to the Flat Rock prosecutor. You have a seat in the hall. He'll come get you. He'll talk to you, see if you can resolve it. Either way, you're coming back in front of me then, okay?
Yeah.
All right, best of luck. Nivea LaRose Clark, 25R514156. All right, this is scheduled for department rep. Defendant failed to appear. Scheduled for 9. It's now 9:34. Default judgments entered. Michael Jacob Collins, 25R514159. This is with the city of Rockwood. This was scheduled for 9 o'clock. It's 9:34. Defendant failed to appear. So I'm going to enter a default judgment on both of those. Lisa, do I have any sentencing ready out there or anything? Do you know?
Not on Zoom, but I do have an attorney that already spoke to the prosecutor. Let me get the name on that one. Matthew Hargis, is that in there?
I don't have it. Do you have?
I don't even know what you guys are talking about, Your Honor.
What's the last name?
Hargis?
You have Hargis.
Hargis did not check in with me, no.
They're on Zoom. He already talked to the prosecutor.
Flat Rock's, the prosecutor has that file.
Mr. Daniel.
Good morning, Your Honor. How are you?
Good. How you doing?
Doing well, thanks.
Are you the one who has Hargis?
No, I have Daniel Miranda.
He needs
Flat
to,
Rock.
you can join the breakout room.
Okay.
Good to have you here.
Yes, thank you. I will be back.
Good. Bradley Eugene Noble, 24R50563, 24R513-857, 25R514169. Your name?
Brad Noble.
So he's going to dismiss the dog running at large here,
Yeah.
but you got to pay these tickets.
Right.
You have the money now?
Yes.
Okay. And you agree that you owe these at least, right?
Yeah.
Tell you what, I'll cut them down to 200 each, okay? You pay $200, balance waived, and then I'm gonna go ahead, and I'm talking about on 563, and the same thing with the case in front of Judge Hessen, 24R513857. You pay $200, balance waived, so you're gonna pay $400. I'm gonna dismiss then the dog at large case pursuant to the agreement that the two of you reached.
Okay.
So that case is dismissed. Go down the hall, pay your $400, balance waived over and above that on each of the civil infractions, and we're all done.
Okay.
Any questions?
I just go down the hall.
Yeah, just keep the dog under control, will you please? Okay, have a good day. Good luck. Yes, right down to the cashier.
I think.
Sir, just one second.
How you doing there, Ms. McRipley?
Good morning, Judge, how are you?
Nice to see you. Mr. Pellin, do you have anything ready for me? If you can hear me?
No, Your Honor, not at this time. The only file I have in here is Miss Ferguson, which I think she's got a sentencing and needs to talk to her attorney.
Okay, thanks.
Yep.
Any conflict between this honorable court and our office, and if any conflict is to arise, we waive that conflict so that this honorable court can hear these matters.
The court, for its part, also does not believe that there's a conflict either in the Michigan court rules or the cases decided thereunder. To the extent a conflict does exist, given the waivers, the court will consent to hear the matters. Court does call the case of the people of the state of Michigan versus Ryan Pfeiffer.
Good morning, Your Honor, James Kennedy, on behalf of the people.
I'd like to welcome up hearing on behalf of Ryan Piper.
Is he? Where is he? Is he? I'm not picking him up.
He is on.
Mr. Pfeiffer, can you state your name, please? Oh, there, I got it.
Yes, sir. Ryan Pieper.
Sure, okay. Thank you. All right, what are we doing today?
So has the court received the evaluation from the forensics?
I have, it is dated June 18th, that one.
Yeah, so we sent an order finding him competent. We have nothing further to present. We would like to set it for probable cause conflict.
Anything from the people? All right. Court, based upon the people of that report, would find that defendant is competent to stand trial. Specifically that the defendant can understand the nature and objects of the proceedings against him and can understand and can rationalize his defense. Therefore, the defendant is deemed competent. Like to set for a probable cause conference?
Yes.
Yes.
Yes, Your Honor.
All right. You want 2 weeks out? Will that be enough time for you?
Yes, 2 weeks should be fine.
Probable cause conference will be set July 10th, 2025, 9 a.m.
Thank you, Your Honor.
Thank
Thank
you.
you.
Bond will continue.
Thank you.
Court does call the case People versus Brian Brown.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Oh, good morning. We do not have Mr. Perkins. Counsel, have you heard from Mr. Perkins at all or his office?
No, Your Honor.
Mr. Brown is not here, is that right?
Mr. Brown is in debate counsel.
Pardon? Oh, there he is. Mr. Brown, can you state your name?
Ryan Brown?
All right. Your attorney has not signed on. Was he coming by Zoom or in person? Pardon? All right, contact his office. I'm going to pass this matter briefly, sir, okay? Try to get your
Yes, sir.
attorney here. Court does call the case of People versus Christopher Nunley.
Student Attorney Kara Rosengren requesting permission to practice under Michigan Court Rule 8.120 on behalf of Attorney Hannah Apple under the supervision of First Assistant PD Michael Gotti.
Permission to practice is granted. Sir, can you state your name, please?
Christopher Nunley.
All right, what are we doing on this?
Thank you, Your Honor. We're requesting to adjourn as Attorney Apple has a meeting scheduled in person in Jackson on 7/25 at 2:30 p.m. with Mr. Nunley. So we're going.
7/25?
Yes, July 25th.
She couldn't get one before then. That's a month out.
Yes, Your Honor. From my understanding, they only allow in-person visits in Jackson on Fridays, Saturdays, Sundays, and Mondays, and only in the
A
afternoon.
lot of those between now and then.
That was the first available that she could get, Your Honor.
July 31st, 2025, 9 a.m.
Okay, thank you, Your Honor.
Court does call the case of the People versus Anthony Lafredo.
Assistant Public Defender Natalie Pate with it on behalf of Mr. Lafredo, who is present via Zoom from the Jackson County Jail. Sir, can you please unmute and state your name for the court?
Anthony Lafredo.
Thank you, sir.
Thank you, Your Honor. I have a video visit scheduled with Mr. Lafredo tomorrow morning at 10 a.m. There is an.
So it's not a month out?
No, Your Honor.
Oh, okay, go ahead.
I finally got approved, but it's scheduled for tomorrow morning. And there is an offer in this matter that I wish to convey to my client. So I would ask for a brief adjournment.
All right. Without objection, July 10th, 2025, 9 a.m. Bond continued. All right. Thank you, sir.
Your Honor.
Thank you, sir. We'll talk tomorrow.
All right, thank you.
Court calls the case People versus Anitra Coomer.
Student Attorney Kara Rosengren under the supervision of First Assistant PD Michael Gotti on behalf of Ms. Coomer.
Coomer, can you state your name, please?
Anitra Coomer.
Thank you.
Your Honor, we're asking to adjourn as we have an application pending for a visit to the Women's Correctional Facility.
Okay, how soon has it been cleared? I realize there's a problem with these visits, but.
Yeah, I'm sorry. I'm unaware, Your Honor, if it's clear or not. I just know that the application is pending. It has been put in.
July 17th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the cases of the People versus Terrell Green.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Green. Mr. Green, please state your name for the record.
Terrell Green. Thank you.
We're asking you to set all three cases for preliminary examination, please.
Discovery is complete.
From my understanding, yes, Your Honor.
People have their witnesses available July 8th. Or where is he?
He's in MDC and with the holiday, I'm a little concerned.
Any objection?
No, Your Honor. He's in county, but he is incarcerated, so either way.
Is he here? He's here?
No, he's
No. Oh, Livingston.
I'm concerned about being able to get a quick turnaround.
All right. Understood. Preliminary examination in person will be set July 15th, 2025, 9 a.m. before Judge Moore. Bond will continue.
Thank you.
Court does call the case of the people versus Robert Moyle.
Alexander.
Brian Bowling on behalf of Mr. Moyle, you're up. Just state your name on the record, please.
Robert Moyle.
Your Honor, we're here to ask for a examination on this matter today. To my understanding, all discovery is complete.
People have their witnesses available.
We'll do our best, Your Honor.
Preliminary examination in person will be set July 8th, 2025, 9 a.m. before Judge Balvo. As to bound.
Your Honor, it's come to my attention that this defendant has made 6 complete calls to the victim in this case, as well as 68 attempts to call. At this time, I'll be asking that his phone please be revoked.
Any response?
Well, Your Honor, I'll just state that that's the first I'm hearing of this. Obviously, I don't know what the substance of those conversations were or that they were actually even placed at this point in time. I'd ask the court to deny that motion.
Defendant's bond will continue in its monetary fashion. However, pending a hearing, if the defendant requests, defendant's phone privileges are hereby revoked.
Thanks, Judge.
Court, you guys got to keep moving. Court calls the case of the people versus Robert, is it Ciotti? Ciotti.
Good morning, Your Honor. Sam Bernstein for Mr. Ciotti. I've been unsuccessful in being able to reach him, so just me today.
Bench warrant will issue for defendant's failure to appear. Bond will be set at $10,000. Cash surety, that warrant will issue immediately. Court calls case people versus Antonio Williams.
Morning, people.
Sin Groper.
In the back.
Pardon?
There was a bunch of them ganged up on.
All right. Your name, sir?
Oh, Antonio Williams.
All right. Mr. Williams, you're appearing here at a probable cause conference without counsel. I will advise you that you are charged with the offense of assault with intent to do great bodily harm less than murder, felony punishable by up to 10 years incarceration and a $5,000 fine plus court costs. Do you understand that, sir?
Yes, sir.
All right. You understand also, as I've indicated, that you're appearing here without counsel. Let me first ask you, is it your desire to proceed without counsel, or do you
No.
wish to have an attorney?
I wish to have an attorney.
All right, this is a public defender case.
First Assistant Public Defender Michael Gaddy on behalf of Mr. Williams, Your Honor.
All right.
I'd ask the court to adjourn the probable cause conference to allow us to obtain discovery, get officially appointed by the appointing authority and
I don't think
matter with
it
Mr.
really does, that doesn't need to be done, but.
Oh, good. Okay.
One at a
I don't
time.
know how.
It's already done.
Oh, great. Okay. Your Honor, I would then ask for an adjournment of the probable cause conference so we can obtain discovery and review it with Mr. Williams.
July 10th, 2025, 9 a.m. Bond continue.
If I could ask the court what the bond is current.
Bond in this matter is currently set at 100,000 cash surety.
Thank you, Judge. We'll come business.
Court does call the case People versus Andy Rosales.
Ashley Lonnie for the people.
Morning, Your Honor, Sam Bernstein with and on behalf of Mr. Rosales. Please state your name.
Andy Rosales.
Your Honor, discovery is complete. We're asking the court to please set this for exam.
People have their witnesses available the 8th.
We'll try, Your Honor.
Preliminary examination will be set in person, July 8th, 2025, 9 a.m. That is before Judge Fleischer.
Thank you, Your Honor.
Thank you, Your Honor.
Bond will continue. Thank you. Thank you. Court calls the case People versus David Merrickman.
Morning, Your Honor, ready to go for the people.
Morning, Honor. Assistant Public Defender Costumble based on behalf of David Merriquin, who is approaching the podium to my right. Mr. Merriquin, can you state your full name for the record, please?
David Merriquin.
All right. What are we doing on this today?
Yes.
Yes, Your Honor. As far as the probable cause conferences, we would ask that these be adjourned to continue negotiations for a global plea. I understand that my client also has a bond violation. He is prepared to admit to that bond violation today.
So he does not wish to have a hearing on that violation?
No, Your Honor. He wishes to admit full responsibility.
And then having admitted to the violation, court will accept that admission. I will adjourn this matter out to July 10th, 2025, 9 a.m. Given the nature of the bond violation and his bond, at this time, his bond is no bond.
So his bond is no bond, Your Honor?
Yes, I think it is at this point. I think I revoked.
You haven't actually addressed that.
I have not addressed the
Yeah,
violation.
that's correct.
All right. Anything from the people regarding that?
Your Honor, I would ask that bond be revoked on this matter. This is a case where the defendant was on probation. The victim on probation matter is the same victim on the malicious destruction case before this court. Given that he was out on tether and still cannot be trusted to follow with that order, I think revoking bond is appropriate at this time.
Any response?
Your Honor, my client has been in for 10 days. I think he's had a lot of time to think about his decision. He did turn himself in on this bond violation. As I understand it, he had a moment of not good decision-making. He thought about it, realized it's not what he wanted. He doesn't want to be on the run, Your Honor. He wants to follow the court's orders. So he turned himself in. He's hoping to get a new tether and get back out and hopefully get back to his job. He has a job in landscaping. He's hoping to keep that job, Your Honor. He is willing to go back out on tether and do whatever the court needs him to do if that's what the court deems appropriate.
The problem is that there was at least a tamper alert and other things regarding the tether. So I don't know that the tether does anything for us at this point, given the defendant's conduct. So for those reasons, defendant's bond will be revoked pending further order of the court.
Understood, Your Honor. Thank you.
Court calls the case People versus James Williams.
People.
Good morning, Your Honor. Christina Costantino appearing on behalf of Mr. Williams. Mr. Williams, can you please state your name for the court?
Yes, ma'am. James Williams.
What are you doing?
Your Honor, this is the date and time set for APCC. I was just recently appointed to Mr. Williams' case, and I do believe there is some outstanding discovery. So I would be asking for an adjournment. We will also be doing some mitigation for Mr. Williams. So I would be asking for about 3 weeks to ensure that's completed by the next PCC date.
Any objection for the people?
No, Your Honor.
Probable cause conference, July 17th, 2025, 9 a.m. Bound continued.
Thank you, Judge.
Thank you. The court does call the cases of the People versus Shavante Vincent. Or Siobhan Vincent.
Good morning, Your Honor. Amy Rise on behalf of the people.
Ready, Judge. Court shall fix the assistant public defender on behalf of Ms. Benson.
Come on.
Hello, how you doing?
Your name, ma'am?
My name is Siobhan Benson, known as Truth.
Thank you, Judge. I believe you were here a couple weeks ago and Ms. Benson was found to be competent.
Yes.
I think at this time we are prepared to set this matter for preliminary examination. I know Ms. Riser was looking into the availability of her witnesses and officers. I don't know if the court had some dates we can look into.
Yes, all right. And all discovery is complete on your.
That's my understanding, Judge, yes.
Gotta let my shirt be seen, stand tall for my daughter.
So, when's mine?
All discovery is complete already. Have some correspondence.
Yes.
With Mr. Feaster this week at the hearing on March 21st, 2025. Detective Roberts advised all counsel that they could bring a terabyte hard drive for the larger documents and downloads that couldn't be emailed or sent over. So I believe that is going to be done by Mr. Feaster this week.
Yes, thank you, Ms. Riser. My client was concerned about getting the information out of her.
Oh, I'm sorry. Yeah, I'm good. I
I
apologize.
My client was concerned about getting some information out of her cellular phones. Ms. Riser indicates that they should have that, and I can get a hard drive and have my investigator go over and get a copy of that tomorrow. From all the evidence in that phone, my client believes there might be some.
Okay, so if they get that to you, I won't be granting an adjournment if for whatever reason it doesn't come through if I'm setting it for exam.
Well, if it's, do you want?
It's done, Your Honor. They just have to get the hard drive.
Okay.
To get the forensic report download.
Yeah, if Ms. Riser says it's done, I believe it's done.
Okay.
So if it's done, we'll get it tomorrow.
then you can- Because the other part of the case was set before me, I'd be setting this part.
That's fine, Judge. Ms. Riser says that your phones have been dumped and that we can get a copy of everything.
Dump like how? Like they took the evidence off of it?
No, it's
I got
preserved for you.
evidence.
Yeah,
Okay.
and we can go pick it up tomorrow.
Yeah, these people were pedophiles, they were demons.
I got it.
They sexually assaulted my daughter and abused
Miss-
her,
Miss Vincent,
period.
Just hold on. All right.
I'm gonna
I'm gonna
expose them. They're gonna be exposed.
Vincent, Miss
I'm sorry.
Please.
Sorry, Judge.
I'll set this for July 22nd. That'll give you time to get that, go through that with your attorney, and it'll properly be set before me
Sorry, Judge, if I could just confirm that I am here
Okay.
on 22nd.
on 9 a.m.
Okay, would you?
Or, I'm sorry, what is it? No, that's a combination date, so it's 12. Okay. No, let's just do it. I'll set it, well, why don't we do this? I'll set it at 1 p.m. on the 21st. On the 22nd, excuse me.
So
July 22nd, 1 PM before me.
thank you. The only witness that is unavailable is one of
Miss
the.
Vincent, you got it?
He's so close, so you know.
No, okay, I got you. But just face this way. Go ahead.
The only witness that is unavailable is one of the sheriff's department witnesses on the sheriff's department case. And I don't know that we'll even get to that on the
21st.
I presume we'll start with the homicide. I'll have those sheriff's department witnesses for the CCW, RNC, RNO on standby.
All right, very good. Okay, so I'll set it.
Are we setting that on the 22nd as well? Do you want to?
I'm gonna set all of them on the 22nd. And then we'll sort them out from there. July 22nd, 2025, 1 PM, that's before me. And we'll continue this tonight.
Thank you very much,
All
Judge.
right, thank you.
Yeah, hang in there.
All right,
All right.
Thank you.
Court does,
Thank you, Judge.
no, Miss Vincent, no. Court calls the case, People versus Clifford Gordon.
Edward Drukas for Clifford Gordon, who is approaching, Your Honor.
Good morning, sir. What's your name?
Clifford Gordon.
All right, what are we doing?
Your Honor, I'm asking just for a 2-week adjournment. There are some outside counsel that I'm using for mitigation, and if I could have 2 weeks.
That objection, July 10th, 2025, 9 AM, bond continued.
Thank you, Your Honor.
Thank you. Thank you, sir.
Thank you.
Court calls the case, People versus Myron Barnes.
On behalf of people.
Morning, Your Honor. Sam Bernstein for Ms. Foster Tucker for Mr. Barnes. Mr. Barnes, could you please state your name for the court?
Myron Barnes. Thank you.
Your Honor, in this case, we are asking for an adjournment resolution, and we will submit an order to the court for release to drug treatment as well.
Probable cause conference will be adjourned July 10th, 2025, 9 AM, bond continued.
Thank you, Your Honor.
Court calls case, People versus Julius Holston.
Edward Drukas for Julius Holston, who is approaching.
Your name, sir?
Julius Holston.
Thank you. All right, what are we doing?
Your Honor, I'm asking for at least a week to facilitate the new form for a misdemeanor plea in this case.
When's my next one? 20, I'm sorry? No, PCC.
Oh, I'm sorry.
I've got the 3rd though.
Yes.
All right. If you've worked out a resolution, it's just a matter of putting it into its form. Is that what I'm to understand?
Yes,
sir. Probable cause conference, July 3rd, 2025, 9 AM, 1 week out. Bond will continue. Thank you, sir.
Thank you.
Court calls the case of the People versus Daniel Bauer.
Morning, Your Honor. Laura Yagi, Assistant Public Defender, with and on behalf of Mr. Bowers. Who's approaching? Mr. Bowers, can you say your name for the court?
Daniel Bowers.
All right, what are we doing?
Your Honor.
Hold on.
Sorry.
I need the other side.
Yeah.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Thank you. What are we doing?
Your Honor, I met with Mr. Bowers and I believe he's prepared. He is signing right now the examination waiver. So I believe he's prepared to waive his preliminary examination. Is that right, Mr. Bowers?
Yes, I am. I waive, Your Honor.
All right. Mr. Bowers, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, I understand, Your Honor.
You understand you'll not have that hearing. You'll proceed to circuit court for further.
Yes, I know. I'm aware of, Your Honor.
Yes, would have done. Counsel, people also waive their right.
Yes, Your Honor.
All right, preliminary examination having been waived, defendant is bound over to circuit court on a single count. Ms. Yagi.
We would waive formal reading and stand mute, Your Honor.
Defendant every way, formal reading, standing mute. Court will enter a not guilty plea. Pretrial in this matter will be set for. What do we not have? Oh, please.
Using their bond. They didn't respond. They don't.
May I object? It's Conlon.
Okay. So if you want to talk over next. Okay. And I've been in touch with you.
Hold on a second. We're not gonna do that. What date is this? Mr. Fleischer, what days are Judge Conlon on?
It's Judge this is,
Pardon? Give me a Wednesday, 2 weeks out.
He's told me when I got arrested on the Navy base.
Pretrial in this matter will be set for July 9th, 2025, 9 a.m. Bond will continue. I suggest that council check that date since I don't have the ones in.
yes, Your Honor, thank you.
Get that down.
Thank you.
Court does call the case People versus Gregory Bell. Don't be so shy about it. Just say it like you mean it. Yeah.
Parallel for the people requesting permission to practice under Michigan Court Rule 8.112 under the supervision of the state assistant.
Ms. Lowe. Is O a number or a letter? Start over.
Requesting permission to practice pursuant to Michigan Court Rule 8.120 under the supervision of Assistant Prosecuting Attorney General.
Permission to practice is granted.
Your defense is going to have to object to this one. No objection, Your Honor, of course, no, especially for a fellow Wayne Stater. Your Honor, today's the date and time set for a probable cause conference. I was very recently appointed to this matter, so we are asking for a brief adjournment, whatever the court's next date is.
Without objection, probable cause conference, July 10th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you.
Thank you, Judge. 9 a.m. Welcome all the way.
Court calls case People versus Norman Johnson.
Alexander, on behalf of the people, Your Honor.
Sam Bernstein for Mr. Johnson.
Yeah.
You say your name.
Norman Johnson. Thank you, sir.
Your Honor, we're asking the court to please set this for preliminary exam. Discovery is complete.
You will have their witnesses available the 8th.
We'll do our best, Your Honor.
Preliminary examination in person, July 8th, 2025, 9 a.m. That's before Judge Valvo. Bond is continued.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case People versus Todd Ammerman.
Your Honor, Lauren Yagi, Assistant Public Defender. Mr. Ammerman has been in touch with my office repeatedly. He's
Right
here.
here.
There you go. Good morning, Mr. Ammerman. Thank you for calling our office. Please say your name for the record.
Todd Ammerman.
Your Honor, I am asking for,
You are way too happy.
I'm very happy to see you
Yeah.
this morning.
Yeah, I'm happy to be here, really. Yeah, with you.
Your Honor, I do anticipate, I was conveyed a plea offer in this case, but I need some time to talk to Mr. Ammerman. This is my first time talking with him, so that's why I'm so excited,
Yeah.
but
We all got that. All right.
I would ask for a brief adjournment
I'll
to
need a
talk.
green sheet.
Thank you, Your
I'll
Honor.
adjourn it to July 10th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you. Court calls case People versus Christopher Atkins. Have we heard any? Christopher Atkins?
He is in. Now it's Mr. Bowles.
Brian Bowling on behalf of Mr. Atkins, Your Honor.
Brett, where is it?
Should be at the bottom of your screen. This camera.
Right, but his camera's off. Christopher Atkins? We're not getting a response. I'll pass the matter briefly as soon as we can do that. Have we heard from Mr. Perkins at all?
Thank you.
Yes, he's in another hearing for about 30 minutes.
For about 30 minutes?
Yeah.
Does the Attorney General have anything else?
Yes, she does. She has one more case.
All right, well, after that one, I'm calling that one and it's just gonna be put over because I'm not gonna wait for him. I'm not gonna have her wait. Court calls the case, People versus Anitha Barnes.
Like we're talking about appearing on behalf of the bar.
Anita Barnes.
Thank you.
Thank you. Your Honor, we are requesting for a 2-week adjournment to review the media with the client.
Have a green sheet?
Sorry? Yes, I have a green sheet.
Probable cause conference will be adjourned July 10th, 2025, 9 a.m. Bond continued. Thank you.
Thank you, Your Honor.
Court calls case of the People versus Jonathan Miles.
Good morning, Your Honor. Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Your Honor, Alexis Plumey on behalf of Mr. Miles. Mr. Miles, could you say your full name?
Jonathan Dion Miles. Morning.
And Your Honor, today's the date and time for a probable cause conference. I am requesting a brief adjournment so that my client can get some bond money together to start working towards that standard offer. Your Honor, I have discussed the standard process with my client. He would like me to address bond if you would allow it briefly.
Probable cause conference will be adjourned July 10th, 2025, 9 a.m. Go ahead briefly.
Okay.
It's set at the 25%.
I
So
understand
you
that.
gotta give me some reasons, otherwise it's gonna stay right there.
Your Honor, so first and foremost, Mr. Miles is just unable to afford the bond as is. He could maybe post $500 tops, and that is with reaching out to family and friends. He just got a new job as a security guard, and he also has another job working for his family's shipping company. He's at risk of losing the job as a security guard right now. If he was released, he would be able to pay $100 to $150 a week towards his arrears. And he also has full custody of his 13-year-old, one of his children, who's waiting for him at home.
I don't need a response from the people. Motion for bond reduction is denied. It's set at the statutory threshold. So bond in this matter will continue. Thank you.
Understood.
Give me the green file now. Court recalls the case of the People versus Brian Brown.
Assistant Attorney General Clarissa Williams on behalf of the people.
What's our writ on Bay County? 2 weeks is still a writ. Okay. Mr. Brown, can you state your name?
Brian Brown.
All right, Mr. Brown, I don't know. It says he's in another hearing someplace, but I'm not going to detain the Attorney General. What I'm going to do is I'm going to adjourn your case out 2 weeks, all right? And we'll let Mr.
Yes.
Perkins know. All right?
Okay, thank you.
All right, then probable cause conference will be adjourned July 10th, 2025, 9 a.m. Bond continued. All right, thank you. Thank you. Court calls the case People versus Roderick Bates.
Jennifer Douglas for the people.
Morning, Your Honor, Mike Gaddy, Assistant Public Defender on behalf of the case. Wait at the podium.
State your name. Robert Bates.
There's still more discovery coming, question and adjournment.
Yes, Your Honor, it's like there's 2 police agencies and we need the video from the second one.
Probable cause conference July 10th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Court calls the case versus Lowry, Kevin Chevalier Lowry.
Charlotte Steffen on behalf of Mr. Lowry.
Your name?
Kevin Williams, Shinabar Lowry Jr.
Thank you. All right, what are we doing today?
Your Honor, we'd like to set up for preliminary examination.
All right, is all discovery complete?
I believe so.
All right. Do people have their witnesses available the 8th?
We'll do our best, Your Honor.
Preliminary examination in this matter will be in person, July 8th, 2025, 9 a.m. That is before Judge Fleischer.
Thank you, Your Honor.
Bond continued. Thank you, Mr.
Thank you.
Court calls the case of People versus Nathan Bell.
Good morning, Your Honor. Amber Theory, Commission Practice 20 under the supervision of Assistant Prosecuting Attorney Ashley Monty.
Watch this. Is that 8.120? Okay, never mind. Permission practice is granted.
Malika Fatima appearing on behalf of Nathan Bell. For the record.
Nathan Bell. Thank you, sir. All right, what are we doing?
So we are requesting for a 2-week adjournment for pending negotiations with the prosecutor. We are waiting for some hospital record confirmation.
Any objection from the people? Probable cause conference, July 10th, 2025, 9 a.m. Bond will continue. And the next hearing, I'm sure your client will know that I expect him to wear all of his pants. All right, thank you.
Thank you.
Court calls the case, People versus Molly Fox. Your name, ma'am?
Oh, my.
Thank you. All right, what are we doing?
Well, Your Honor, I am going to ask for another short adjournment, and I have made up paperwork, and also ask you to grant bond again. The reason I'm asking for the adjournment and the reason I'm asking for bond are somewhat connected, and that is that she hasn't yet been interviewed for whether she would be eligible for the recovery court. Mr. Kennedy was kind enough to recommend or suggest that resolution to me. And yet, as I read the eligibility requirements, and as I talked to Annette Johnson this week, she would not normally be considered a candidate because this is an assaultive crime with which she's charged. But the circumstances of this case suggest that the incident that she's charged with had, had alcohol was a very significant contributing factor, and that she has a need for some kind of treatment. In fact, she had been
Ms.
doing,
Dennis, we addressed bond the last time that we were here.
that's true. She's been in
And
there
I
months
and I
now.
denied the change in her bond. I don't know that anything has changed between that time and now.
Well, the only thing that may have changed, I don't recall what the assistant prosecuting attorney said last time. I don't really remember what she said. She was a sort of a fill-in, not the person who really is handling her case. Mr. Kennedy apparently has told me that he would be, if you were satisfied, he would be satisfied if she had maybe twice a week drops, because
If you guys want to submit a stipulated order, I will look at it and I will consider it. I don't know that there's anything that you're going to tell me that will lead me to change my mind from the last time I addressed it.
The other factor, Your Honor, is as I know you know, the recovery court is very labor intensive, you might say. It's extremely difficult to do, and in my opinion, I represented her in other matters. She will not be successful in the recorder's court unless she has full support of her family. But while she's in prison, in jail, it's difficult for her to talk to her family in this kind of a way.
Ms. Dennis, you made that exact same argument to me the last time.
Well, it's still true.
Okay, and my answer is still the same.
Okay.
Probable cause conference will be adjourned July 10th, 2025, 9 a.m. on continue. Motion for bond reduction is denied.
Thank you, Your Honor. Your Honor, would the court like a copy of the certificate of completion for the substance abuse that she has completed in jail?
Pardon?
Would the court like for your file a copy of the certificate of completion for the substance abuse treatment that she's had in the last?
You can send that to my staff. We'll get that to the file.
Okay, thank you, Your Honor.
Court calls case People versus Dominic Billing.
Andrew Childers appearing on behalf of the
Your Honor, Alexis Pluma, here, just a,
Dancing or what?
appearing with and on behalf of Mr. Billing. Mr. Billing, could you just state your name?
Dominic Billing.
Your Honor, I am just requesting a brief adjournment. It's Mr. Billing's first probable cause conference. We'd just like to discuss the case a little more before he decides what he wants to do.
Without objection, July 10th, 2025, 9 a.m. bond continue.
Your Honor, would it be possible to go out one more week? That's my client's birthday.
Well, we'll all sing.
Please, can we go out one more week?
For a birthday?
Yeah. I mean, as much as I enjoyed being here on my birthday.
Wow. I didn't tell you to take that job. Did you hear that? I don't know. She used to be so nice. So what's this year, like birthday campaign? Anybody's birthday? We're not.
Yeah.
Okay. You know, you're lucky I like you. July 17th.
Thank you, Your Honor.
Court does call the case People versus Daryl Frederick. Maybe Darrell.
I'm Laura Yagi, Assistant Public Defender with and on behalf of Mr. Frederick in 4 of the matters.
And Edward Drukas on behalf of Mr. Frederick in 5526 and 327.
Your name? Daryl Frederick. Thank you. What are we doing?
Your Honor, in the 4 public defender cases, I do believe discovery is complete. We are respectfully requesting that they be set for exam. I think Mr. Drukas is doing something different in his case, and I do have a physical waiver if he is.
What are you doing on your cases?
We were gonna set ours for exam.
Oh, never.
So all of them are
Sorry.
gonna be set for.
Okay, perfect.
All right, that's fine. Discovery is complete in your cases, Mr. Durkis.
Yes, Your Honor.
People have their witnesses available on the 8th. Preliminary examination in person, July 8th, 2025, 9 a.m. All of these are before Judge Valvo.
Your mom is here.
Bond will continue.
Okay. Thank you.
Court does call the case, People versus Daniel Bowe.
You're Raymond Cook for the people.
Talking about hearing on behalf of Daniel Bowe.
Really?
State your name for the record.
Daniel Bowe.
Thank you, Your Honor. At this time, we are requesting a 2-week adjournment.
Just came from the hospital.
We are requesting a 2-week adjournment to verify receiving the media and discovery. I believe it was sent over to our office yesterday.
July 10th, 2025, 9 a.m. Continue. And you'll talk to him about his attire.
Yeah, no, I just left the hospital this morning with my son.
Oh,
That's the only reason.
understood. All right.
Thank you, Your Honor.
Thank you. Look at those 1980s parachute pants. Just have them here. Anyway. Court calls case People versus Shania Williams.
And is it on behalf of the people, Your Honor?
Morning, Your Honor. Sam Bernstein with and on behalf of Ms. Williams. Ms. Williams, could you please state your name for the court?
Shania Williams.
Your Honor, we're asking for an exam date. Discovery is complete.
People have their witnesses available on the 8th. Preliminary examination in person, July 8th, 2025, 9 a.m. That is before Judge Fleischer. As to bond.
Your Honor, it's come to my attention that the defendant is, while not calling the victim on this case, in her jail calls, I've heard a few concerning things. One of those being that talking to a friend saying that if the dad wants, who's the victim in this case? If her dad wants money, they'll bring the money, not to come to court. She also asked the friend to stop her dad and his wife at the door of the courthouse before they can get in the courtroom today. So the case will be dismissed. I have concerns that she's contacting people to try and interfere with the witness participating in this case. So I would ask at this time that her phone privilege be revoked.
Respond.
I'm sure Ms. Zenda will send me the phone calls. I'll listen to them and I'll notice it up for motion if appropriate, Your Honor.
All right. Defendant phone privileges pending any hearing requested by the defendant are hereby revoked.
I'll see you on the action.
Her bond will continue. Court calls case of the People versus Zaria Brain.
And then on behalf of the people, Your Honor.
And Assistant Public Defender Jay Ballinger on behalf of Ms. Brand. Ms. Brand, can you please state your name for the record?
Zaria Brand.
Okay, messed it up, I'm sorry.
And Your Honor, we're just asking for a few weeks of an adjournment. I'm seeking to do some mitigation, submit that to the prosecution for their.
You have a green sheet.
I do, Your Honor. I apologize. I have that right here.
July 17th, 2025, 9 a.m. Bond continue.
Thank you.
I'll call him Monday, okay?
Okay.
All right, take care. Thank you.
Court calls the cases of the People versus Taruska Dennis.
Jacob Kennedy for the people, Your Honor.
Talking about hearing with non Zachariah Dennis.
And good morning, Your Honor. Christina Costantino, appearing on behalf of Mr. Haruska Dennis. And I am appearing on the other case number.
So you don't come down to see us anymore?
Judge, I do, trust me.
No, I'm not gonna say anything.
I'd
No,
rather-
I wasn't
I'd
gonna say
rather
anything.
be
I'm just gonna
there
leave
than-
it. It's like been 3 weeks.
I
Fine.
know.
I don't care.
I know. I'd much rather be there than where I've been, trust me.
Okay. What are we doing?
Judge Rahus, Dennis, Your Honor.
Thank you.
Your Honor, I believe we received the AIM report yesterday to our office, so we are requesting for a 2-week adjournment to review that.
How long?
2 weeks.
Any objection?
And Judge, I would be
And that's
requesting the same on my case.
Okay. Probable cause conference will be adjourned July 10th, 2025, 9 a.m. Bound continued. I'll need a green sheet, counsel.
Thank you, Your Honor.
Thank you, Your Honor. Thank you, Judge.
Court does call the case of the people versus Cordell Brown.
Your Honor, Alexis Pluma appearing on behalf of Mr. Brown. Your Honor, I haven't been able, I don't think he's here.
It's his birthday or something?
It could be his birthday or something. I haven't been able to reach him. I was able to confirm that he was released from the hospital. That looks like his phone is disconnected. So
Defense warrant will issue for defendant's failure to appear. Bond 10,000. Cash surety. That warrant will issue immediately.
thank you.
Court calls the case People versus Quincy Jones.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Jones, who's approaching, Your Honor.
And good morning, Your Honor. Sydney Rushing, appearing on behalf of Mr. Jones in case ending in 0697.
And my case is 21F105474FY. Judge.
All right, what are we doing?
I believe we have reached a resolution in these matters. We have the plea forms here. We did not submit them yesterday. We'd ask the court to make an exception or to adjourn this matter 1 week because we have all the documentation here.
Is that going to be on both cases?
Yes.
Probable cause conference will be adjourned July 3rd, 2025, 9 a.m. Bound continue.
I have.
Thank you so much, John.
A green sheet in that eventuality. If I could be heard on bond, Judge.
Go ahead.
Thank you. Mr. Jones is, well, obviously he's here. He was taken into custody last time for failing to go to community corrections. He reports that he did
Not just failing to go. There were some other issues, but go ahead.
He reports that he was released afterwards. He would avail himself of community corrections if released in this on this occasion. Also, he would be. I haven't been in contact with his worker over at Avalon, and they are willing to provide him with transportation if need be.
So how do we stop him from using?
Your Honor,
I know, hard question. Yeah.
he could be testing. He could do the CC, the community patients outpatient program while he is waiting this matter. He does live locally in Ann Arbor through the Avalon program.
I don't need a response. He was significantly intoxicated. Unless I see a full plan in place, I'm not doing anything along those lines.
Thank you, Your Honor.
Bond reductions tonight.
Thank you so much, Your Honor. Have a great day to you and your wonderful staff.
You too. Court calls case People versus Amanda Bryant.
Stephanie Cannon on behalf of Ms. Bryant, Your Honor.
Oh, I didn't know you had any case.
My apologies, Your Honor. What'd you say?
No.
Oh. Oh, my pen.
Do you have a client?
Oh, thank goodness. Your Honor, I'm not sure who that young lady is on the screen. However, I have not communicated with my client. There's no name. It just says name ? So I'm not sure who that is.
Okay, ma'am, if you want to tell us who you are, you got to unmute.
Your Honor, that is not my client. So I'm going to ask for a bench warrant. Or I'm sorry, for show cause.
I'll take your
Show
first
cause.
suggestion.
Show cause, sorry.
Bench warrant will issue.
Thank you, Your Honor.
Council's request, bond will be set 10,000 cash surety. That warrant will issue immediately. Wow. Just forget which side you're on. Court calls the cases of the people versus Spencer Norton.
People, Your Honor.
Good morning, Judge Jeff Perlman on behalf of Spencer Norton.
Good morning, sir. Mr. Jerkis, are you also?
Your Honor, I indicated with brother counsel, and he's substituting in. He had asked for permission to sign my name and get those forms to the court. I know that's being facilitated.
But we don't have them yet, right? We do? Okay, they're in. Okay. All right, great. Okay, he's in on all of them now.
Thank you.
Thank you. All right, your name, sir?
Spencer Norton.
Okay, what are we doing on these cases?
Yes, Judge, I've received discovery from Mr. Drukas and from the prosecutor's office, and we're asking to schedule these matters for exam.
So, and you believe all discovery is complete, sir?
Yes.
All right. Would the people have their witnesses available July 8th?
We'll do our best, Your Honor.
Judge, I do have an exam that day. Is the court available? Well, I'm sorry, would the court be available in the afternoon on the 8th?
Well, I'm sure it might be, but I'm not here, and we set them all at 9 a.m. in the morning. I can give you the following week if that's what you want.
The 22nd, Judge, if that works, because I'm going to be out of town the 15th.
Preliminary examination will be set July 22nd, 2025, 9 a.m. That's before Judge Barr. Correct. 9 a.m. before Judge Barr.
Thank you, Judge.
Thank you. Bond will continue in these matters.
Thank you.
Thank you. Have a good day.
Okay. Court does call the case of the people versus Andrew Burke.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Burke, who is present via Zoom. Sir, can you please unmute and state your name for the court?
I'm sorry, Andrew Burke.
Thank you.
Thank you, Your Honor. I'm respectfully requesting an adjournment to receive and review the media discovery in this case. I have discussed this with both Mr. Cook and my client.
Probable cause conference July 10th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. Thank you, Mr. Burke. You're all set for today.
Thank you.
Court calls case people versus Timothy Folsom.
And then on behalf of the people, Your Honor.
Who they have?
Yes.
Asli Bashir on behalf of Timothy Folsom.
Your name, sir?
Timothy Folsom.
Thank you. What are we doing?
We're requesting the earliest available preliminary exam date,
Discovery is complete.
to our knowledge.
People have their witnesses available the 8th.
We'll do our best, Your Honor.
Preliminary examination in person, July 8th, 2025, 9 a.m. That is before Judge Fleischer.
Thank you, Your Honor.
Thank you. Bond will continue. Court calls case people versus Jamie Burke.
Your Honor, Alexis Plumai on behalf of Mr. Burke. Your Honor, I haven't been able to reach Mr. Burke. I did speak to his mom yesterday. She said she would tell him to call me. but I haven't got a call back, and obviously Mr. Burke is not here.
Mr. Burke went to 15th District Court.
Ah,
He had contact with the clerk's office. That was about.
Your Honor, could we pass the matter?
Why are you helping her? What?
I would join the defense counsel's request for bench.
I'll pass the matter.
Thank you.
Court does call the case of People versus Matthew Fonseca.
I'm not ready to put the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Fonseca. Mr. Fonseca, please state your name for the record.
Matthew Louis Fonseca.
Thank you.
Your Honor, regarding the PCC, we're asking for an adjournment. Mr. Cook and I are engaged in resolution discussions, and I would like to address bond if I may. Thank you, Mr. Allen.
July 10th, 2025, 9 a.m. Yes, as to bond, Ms. Perry.
Mr. Fonseca's bond on this case, as well as another case pending before Your Honor, is 510%. To me, that sounds like a credit type of bond. When Mr. Cook and I discussed it prior to the hearing, he did have. She
just makes up stuff.
It sounds right to
No,
me, but he did have holds at the time of the arraignment, which are no longer holding them. So I wonder if that was the magistrate's intention. Regardless, I don't want to put words in the magistrate's mouth, but I would be asking for a personal bond for Mr. Fonseca. This is a nonviolent felony charge, Your Honor. He's been very communicative with me. He's eager to resolve all of his cases. He would be staying at the Delana Center if released. He had employment at Gandy Dancer prior to being incarcerated.
What's the other case, though?
The other case is a retail fraud before Your Honor. And then he has two cases out of 14A2 misdemeanors that have $1 each. So his,
excuse me?
Yeah, $1 each. So his total bond holding him is $102, but he's unable to post that.
Yeah. You believe that?
Do you believe it, Mr. Allen?
Sorry, didn't mean to put you on the spot. Is there a response from the people?
No objection from people. I just note two out of county from Adrian. I see they are inactive holds for a large weekly auto and attempt R or just a full RNO. I don't believe they're going to be picking up on those.
Bond in this case is reduced to a $500 personal recognizance bond. In this matter, so I'll grant the motion for bond reduction. Yeah. What is the other matter before me, Seth?
The second.
The second. So if you get a stipulation to me, I'll sign off on that one.
Thank you, Your Honor.
All right. So that court does call the case People versus Bradley Chavez.
Thank you, Eric Austin, based on behalf of Mr. Bradley Chavez, who's present to my right. Bradley, can you state your full name for the record, please?
Bradley Chavez.
Thank you.
Today's the date and time set for probable cause conference. At this time, we're going to be requesting an adjournment. Our office has not received discovery as of yesterday in the evening.
July 10th, 2025, 9 a.m. bond.
Thank you, Your Honor.
Thank you. Court calls case People versus Douglas Hill.
Stephanie Cannon on behalf of Mr. Hill, who's appearing to my right. Mr. Hill, could you please state your name for the record?
Douglas Hill.
Your Honor, we are just simply asking this case be set for a preliminary exam.
You sure?
Yes.
No, I'm kidding.
Yes.
Just asking.
Yes.
Never quite know what you're asking. Is discovery complete?
To my knowledge, it is, yes, Your Honor.
People have their witnesses available the 8th.
That's fine.
Preliminary examination in person will be set July 8th, 2025, 9 a.m. before Judge Fresh Hour. Bond continued. Court does call the case, People versus Deshaun Clifton.
Stephanie Can on behalf of Mr. Clifton.
Your name?
Deshaun Clifton.
Your Honor, we are simply asking for a 2-week adjournment. He's gone through our AIM process. It's my understanding we will have the information, so I should be able to mitigate this down, or hopefully mitigate it down.
That objection, July 10th, 2025, 9 a.m. Bond continued. Thank you. Court calls case, People versus Mark Hubbard.
And then on behalf of the people, Your Honor.
Ready, Judge. On behalf of Mr. Mark Hubbard, who is approaching the podium.
Your name, sir?
Mark Hubbard.
Thank you.
Thank you, Judge. I have spoken to Mr. Hubbard and to the people on this matter. We are requesting a 2-week adjournment. There are some videos that were turned over to our office. Mr. Hubbard would like to review those a little further and have me review them with his with one of the family members who helps him make some decisions.
July 10th, 2025, 9 a.m. Bond continued.
Thank you, Judge.
Court calls case, People versus Antoine Coleman.
Ready, Judge. Court shall please first assistant public defender on behalf of Mr. Coleman, who is approaching the podium. Record, sir.
Antoine Coleman.
Thank you, Judge. Mr. Coleman has started the evaluation process with 14B Recovery Court. That is not yet completed. If we could have a brief adjournment, please.
Probable cause conference, July 17th, 2005.
Thank you, Judge.
Bond continued.
My birthday, July 6th. Thank you.
All right, thank you. Court calls the case, People versus Stephen Johnston.
And Laura Yagus is public defender with, and on behalf of Mr. Johnston, who is standing to my right, could you state your name for the court?
Stephen Michael Johnston.
Your Honor, I do have a green sheet here. I am asking for another adjournment. I know it's been adjourned a few times, but I would ask for another adjournment for continued conversations with Mr. Johnson. We're attempting to set up a plan for him to get into treatment.
Got it. July 10th, 2025, 9 a.m. Bond continued.
Thank you, Your Honor.
Court does call the case, People versus Parker Davis.
Morning, Your Honor. Maybe both of the people.
Mr. Public Defender Jay Bellinger on behalf of Mr. Davis, who is approaching. Mr. Davis, can you please state your name for the record?
Parker Bradley Davis.
And Your Honor, we're just requesting a 3-week adjournment for purposes of mitigation. I believe I will have that completed next week, and I'll send that over to the prosecutor for review.
July 17th, 2025, 9 a.m. Bond continued.
Thank you.
Court calls case, People versus Jeffrey Lewis.
Assistant Public Defender Jay Bellinger on behalf of Mr. Lewis, who approaches. Lewis, can you please state your name for the record?
Jeffrey Scott Lewis.
And Your Honor, I believe we have reached a resolution in this matter that would require a waiver. So my client's prepared to do that today, and I'll let Mr. Kennedy put that offer on the record.
The offer is to join the cost for purposes. That's a max penalty $1,000 fine, and count 3 of accused of the crime, imprisonment of 4 years or more, or less than 10 years. Sentencing agreement and bail probation conditions as set forth by probation.
That is my understanding of the agreement, Your Honor.
Sir, you're waiving your right to a preliminary examination?
Yes.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right.
Yes, sir.
Preliminary examination having been waived, defendants bound over to circuit court on the 3 counts.
Thank you, Your Honor. We acknowledge receipt of information. Waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute. Court will enter a not guilty plea. Pretrial will be set for
July 17, 2025 at 1:30.
July 17, 2025, 1:30, Judge Slay.
Thank you.
Bond continued.
Thank you.
Thank you.
Court calls the case of People versus London Daughtery.
Ready, Judge. Court shall cease to assist in London Diary. Sent to my right at the podium. Please state your name for the record, sir.
London Daughtery.
Thank you, Judge. Spoken to Mr. Dowder and to Mr. Childress. My understanding is the people have made a request to see if there's any body cam or video footage from the car in this incident. They're going to confirm that, so I'm asking for a brief 2-week adjournment, Your Honor.
Probable cause conference will be July 10th, 2025, 9 a.m. Bond will continue.
Thank you very much, Judge.
Nobody at the door. Court does call the case, People versus Jaleesa McDowell.
And then on behalf of the people, Your Honor. Asli Bashir on behalf of Jaleesa McDowell.
Jaleesa McDowell.
In Your Honor, we would like to address bond in this matter and request the briefest possible adjournment.
Okay. Go ahead. I'll let you address mine before I give you the date, I guess.
Thank you. Before I kind of address the substantive bond in this matter, I do want to address kind of clerical error in another case. The court may see that for case, there's a case out of 1482, 25203, or, oh, sorry. Okay, actually, no, I'll save that for the end if it comes up. Just because it looks like she's being held on another matter for a higher bond than she actually has, at least in the system that I.
Out of my court?
Oh, sorry, 1482.
So
Oh,
what
so-
would you want me to do with that?
Well, in case that was part of your consideration for.
Oh, I see.
Apologies.
You don't want me to change it.
No, I do. Oh, so as far
Well,
as this
but I
matters,
won't.
yeah.
You can go to Judge Barr, but go ahead.
So as far as this court is concerned, Ms. McDowell is being held on a $50,000 bond. This is the result of an emergency bond motion and the court's order in response to that motion, that hearing on the June 16th. Circumstances have changed since that hearing. My understanding is at that time, the complaining witness was residing very close to where Ms. McDowell resides.
Have the circumstances changed to the extent that the allegation of a knife to the body or hand of a 15-year-old has changed?
Yes. Well, the charged, alleged, conduct in the police report, as far as that report, which, we have not had any substantive, hearings on the merits on that matter, but the report hasn't changed to my knowledge. But we have, stood mute on that matter.
Yeah, screenshots.
Yeah. And we do, we are gathering discovery on the matter. And I would say in terms of the kind of concerns related to bond about Ms. McDowell being close to the complaining witness, I do believe that the complaining witness, I understand, is residing in Detroit with her grandmother. She no longer resides next door to Ms. McDowell. Ms. McDowell also she's been in custody for 15 days on this matter. She is willing to go on GPS tether. She has, support in the court. She has a coworker and friend who is here today. Her sister was planning to be here today, but was not able to. I do think that additionally, the hardship of her being in custody is something I request the court take into account. She's concerned about the security of her residence. She's been informed that there has been potential vandalism and potential people breaking into her home while she's been out. No one else is officially residing there. Ms. McDowell there's no allegations of Ms. McDowell trying to contact the complaining witness. There's no allegations that she's been making jail calls. She has no intention of contacting the complaining witness in this case, and she understands the seriousness of that. And so I do believe that the being held in custody on a $50,000 bond is excessive in this matter. We can address. Okay.
You're saying the bond I set was excessive?
Well, at present, given the
Okay,
current
go ahead.
circumstances, which have changed, the information you had before you then is not the same as the information as it is now. Of course, I would not question the court's judgment. But specifically, because of the potential hardship to her and the concerns about her home, the concerns about the fact that she is no longer anywhere near, she won't be anywhere near the complaining witness. And she has already been in custody for 15 days. The final matter is, she works as a supervisor at her workplace. She's been there for 5.5 years. She is very concerned about, her job. And so I would request, that she be able to be released to work. I understand that one of the release conditions includes a GPS tether. She's happy to go on a GPS tether and follow any conditions this court thinks are appropriate for her to be released. But if the court would consider, her.
Where are the other two children?
My kids were left at home attended for 2.5 weeks, sir. And I literally moved my kids to Detroit to my mom. They are safe now. And I did sign my rights over, sir. But my children were left home attended for 2.5 weeks. I sent cash up money to them.
This is Ms. McDowell. I don't think we want to address anything with the children right now, other than the fact that they're residing with a grandmother.
I got the move. I just want you to know that, sir.
And Ms. McDowell, all 3 children are living with the grandmother.
And I've been working from my jail cell for 3.5 hours a week because I had to still provide for my children because I knew that they were home left attended. I have that on recording on the jail cell as well. With the CPS lady, her name is Tiffany Avery, sir.
And to be clear, this is not a conversation involving the children. It was just.
And I've never been accused of anything violent. The other accused, the malicious property destruction, I have a $10 bond, sir. And that is taken care of. And it was just you prosecuted her rapist, and that was the
Ms. McDowell, I think if you can just hold off on saying, I think we'll address anything.
I just wanted to speak up for myself, sir, because I'm not a criminal, sir, and I really, really do need to go to work, sir. I've exhausted my funds, and I've been taking care of my children for 2.5 weeks. I didn't make contact, but I did know that they were home by themselves. And it just was discovered. And the CPS worker is going to be providing those information as well. I'm sorry, sir.
That is all, Your Honor.
Your Honor, the court's familiar with this case. I'm not going to re-exhaust the motion that we filed. The only thing that I see that's changed since last hearing is that the children have been placed with that grandmother in Detroit. The facts of this case still stand that she is stabbing her daughter with a butter knife so severely that her daughter needed stitches in her hand. I mean, I have severe concerns, and not only that, she threatened to kill her daughter, and her daughter was so afraid to contact police. She had to text a friend to call police because she was so afraid of her. I mean, I have great concerns, even if she is released, for her children's safety. And this is a very significant case. And I believe in our bond form, our original request was $100,000, so $50,000 as set by the court is appropriate in this case and should remain as set.
Your Honor, if I may address that, There is no history of violent conduct between Ms. McDowell and the complaining witness in this case. The basis of the statements that were just made by the people are entirely the police report in this case.
And
Again,
her stitches.
Oh, well, the basis of the allegation that Ms. McDowell is the cause of the injury is based on the police report. That has not been addressed on the merits. And again, there's no history of legal issues or reports of violence between Ms. McDowell and her children. I would say, I don't believe, I would like the court to consider the gravity of holding her in custody on the basis of just the police report at this stage of the case, with no allegations that she has violated her.
Telling me it's wrong that the child was at the hospital getting stitches, counsel, and that's what I should consider?
I want the court to consider the fact that that Ms. McDowell has stood mute. The court has entered an act.
I understand all of that, but you're asking me to consider her hardship and saying that there are certain things that may be objective in that police report that I shouldn't consider that.
I would like the court to consider the fact that Ms. McDowell is no longer going to be anywhere near that child. So if there is a concern about the possibility that that injury may have been caused by Ms. McDowell, which we deny, that would be addressed by that fact. In addition to the fact that there would be a GPS tether as part of her bond conditions.
And I did also want to make the record clear. She does have a previous conviction for domestic violence from 2018. She also has a previous conviction for larceny from 2020, and she also has the pending case of the MDOP with another domestic relationship. So I mean, I do have concerns. She does have an assault history, and given this case, I'm concerned that it's escalating from what her previous history is.
Your Honor, none of these cases involve Ms. McDowell's children.
Yeah, but you said she didn't have a violent history. She got a DV conviction. Motion for bond reduction is denied. Bond will continue.
And Your Honor, did we set a date?
I don't know, July 3rd, 1 week out. 9 a.m. Court calls case People versus Tommy Lee Ellis.
Hello, basically on behalf of Mr. Ellis, Your Honor, who's present to my right.
Okay.
Thomas Ellis.
Thank you.
I ain't been called Tommy in many years.
Pardon?
I ain't been called Tommy in many years.
All right, what do we do?
Your Honor, I'm going to be requesting an adjournment to the July 17th date. My client has been screened with a 14B recovery court. We're just waiting to see if he's accepted into that or not.
You're going to take him to the 17th to do that?
Well, next week, or I'm sorry, that's the next available date.
Birthday.
No, I haven't.
He has some medical issues that he needs to take care of.
Gotcha.
I think that.
Probable cause conference, July 17th, 2025, 9 a.m. Bond continues. All right, thank you.
Thank you, Your Honor.
Court calls case People versus Alexander McMullen.
Assistant Public Defender Chelsea Vergils with and on behalf of Alexander McMullen, please state your name.
Alexander McMullen.
Thank you.
Your Honor, today we are asking to set a preliminary exam and asking to address bond.
All discoveries complete.
Yes, I believe so, Your Honor.
People have their witnesses available the 8th. Preliminary examination in person, July 8th, 2025, 9 a.m. before Judge Fleischer. As to bond.
Your Honor, we're asking you to consider release on a personal bond with a home confinement tether. Mr. McMullen is a local man. He has family in Washtenaw. He proudly graduated from Milan High School and had been, prior to his incarceration, working part-time at a hotel in Ann Arbor. He does have a parole hold, but he has spoken with his parole officer and does not believe he would be violated for this case. So he hopes to just continue on with his parole.
Do you have confirmation of that?
I don't, Your Honor. No, I haven't spoken with the officer. That concludes my request for a bond.
Any response from the people?
I mean, Your Honor, the defense tried to appeal the existing threatening police. He was cited by the police officers for breaking in cars. They attempted to stop him, jumped in the car, to chase crash before.
that fled that vehicle was apprehended shortly thereafter by police. He has, it's taken a while.
But needless to say, he was on parole at the time of this.
Was just given a year in jail for
Motion for bond reductions and not bond broken.
Thank you, Your Honor.
Court does call the case People versus Durantu Francis.
Ashley Lonnie for the people.
Stephanie Cap, who's appearing by Zoom.
Your name?
Durantu Francis.
Thank you. All right.
And Your Honor, we are going to waive our right to preliminary exam in this case.
All right. Is that a correct statement, Ms. Francis?
Yes, Your Honor.
All right, you understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that the offenses alleged were committed and that you committed them.
Yes, Your Honor.
You understand you'll not have that hearing and that you'll proceed to circuit court for further resolution.
Yes, Your Honor.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on count. Now, how did they do this? Oh, I see what they did. All right. On count 1 with 2 and 3 following.
Thank you, Your Honor. We would waive formal reading of the information and we just ask for our pretrial date. Oh, we stand mute as to the charges. Sorry.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea as to all charges. Pretrial will be set for
August 20th, 2025 at 1:30 with Judge Thomas.
August 20th, 2025, 1:30, Judge Conlon.
Thank you so much, Your Honor.
Thank you. Bond continued.
Thank you, Your Honor.
Thank you. Good luck to you, man. Court calls cases of the people versus Jacqueline Murray.
Good morning, Assistant Public Defender Lauren Penny on behalf of Miss Murray, who is approaching. Miss Murray, please state your name for the record.
Jacqueline Murray.
Your Honor, we are requesting adjournments on the 3 cases. We're working out a plea that would hopefully encompass all cases and is dependent on Miss Murray completing the in jail Dawn Farm program, which she's already enrolled in.
So just so that I'm clear, the plea is contingent upon her completing that.
Yes.
How much more time does she have to go in that?
I have no idea. Every time I have class, I'm here, so in court, so.
All right. Well, I'm trying to anticipate a date that she might complete.
Well, I think it's an 80-day program. She has started attending, which is good because there is a wait list. She is serving a 93-day sentence out of another court, right?
I think this one.
So.
Well, why don't I do this? Also, so that she's not missing classes. Why don't I adjourn this then to August 7th? Okay.
And if the circumstances change, we'll get in
Right,
touch.
then you can get to the court and we can move her date up since she's in custody, but I think she's missing class when she's here. I think that's what she's telling me. I
Yeah.
don't want her to miss class. That's gonna be it. All right?
Thank you, Your Honor.
Thank you.
Thank you. Court does call the case, People versus Jalen Kendrick.
And then on behalf of the people, Your Honor.
Assistant Public Defender Jay Bellinger on behalf of Mr. Kendrick, who appears via Zoom. Mr. Kendrick, can you please state your name for the record?
It's Alan Kendrick.
Thank
Your Honor, maybe briefly approach.
Yes, you may.
behalf of Ms. Student Attorney Kara Rose Friend under the supervision of First Assistant PD Michael Gaddy. On behalf of Mr. Peterson. Mr. Peterson, can you state your name for the court?
Benjamin Donald Peterson. Thank you.
Your Honor, we're going to be requesting that the court set a date for Mr. Peterson's exam, and we'd also like to address the issue of bond when the court's ready.
You have all discovered.
Yes, to my knowledge.
People have their witnesses available the 8th.
We'll do it, Mr. Chairman.
Preliminary examination in person, July 8th, 2025. 9 a.m. before Judge Fleischer.
Thank you, Your Honor. May I address that?
You may.
Your Honor, our client has informed us that he has no prior convictions and he was extradited from the state of Missouri where he resides. He is willing to stay on a GPS tether and remain in the state of Michigan, or alternatively, he can leave the
So
state.
we had to extradite him?
Yes.
Hey, go ahead.
Or alternatively, he can leave the state of Michigan and not return, and he's willing to do all of his court hearings over Zoom. He does have employment.
Why would we do that if we extradited him? I mean, what? Did he waive extradition? But we had to get him here, right?
Yes, sir.
So if we had to bring him from another state, and I'll wait for your answer, why would I let him leave this state? And why would I let him basically be out of custody at this point?
Well, Your Honor, he's willing to stay in state on a GPS tether.
But he wasn't willing to come here to address these issues.
Yeah, he waived.
Go ahead, I'll let you complete your argument for the record, but.
Okay, thank you, Your Honor. I appreciate it. We were just requesting a personal bond, or if the court was not inclined to grant this, a lower bond with a 10% option.
Okay, I don't need a response, but thank you for standing. Most for bond reductions denied. I think it's rather evident on the record as to why the court is denying that. So his bond is denied. The exam is set for the 8th. Thank you.
Thank you, Your Honor.
Clerk calls the case People versus James Taylor.
Our attorney requesting professional practice pursuant to Michigan Court Rule 8.120 under the supervision of AP Andrew Taylor's government.
Duration to practice is granted.
Edward Drukas for James Taylor, Your Honor.
All right.
And I don't see him coming up to the podium. I had been in.
Because he's not.
He did get released out of Ingham County. I had been in communication with his attorney up there. I did get a new updated contact information, and he may not be aware of this date. I've not been able to speak.
Really?
Mr. Taylor. His last date, he was in Ingham County, and I don't know if, but got released shortly thereafter.
He has a bond violation pending, which may be a result of him being in custody, but he hasn't come down to do anything. Bench warrant will issue for defendant's failure to appear. Bond is set in the amount of $25,000 cash surety. That bond will issue immediately. Yes. Court does call the case of the People versus Barrage Scott.
For the judge. Court shall feast on behalf of Mr. Barrage Scott, who is approaching the podium. Mr. Scott, please state your name for the record.
Well, I was gonna say Scott, so.
How you doing?
All right, just glad to see my family in here, that's all.
Thank you, Judge.
Been here every time for you. All right.
Thank you, Judge. I believe this is a competency review. My understanding is that we do have a report. Scott is competent, Your Honor.
Yes.
We stipulate that, Your Honor.
And the people?
But also stipulate the defendant's comment.
All right. The court, having reviewed the report, would find that the defendant is competent to stand trial. Defendant can understand the nature and objects of the proceedings against him and can rationally assist in his defense. Therefore, the defendant is found competent.
Judge, I'd be asking this might be set for a PCC, and Mr. Scott would like me to address bond as possible.
All right. Probable cause conference will be set for July 10th, 2025, 9 a.m.
Thank you, Judge. I've had a chance to talk to Mr. Scott about the situation, and I've relayed to him how serious of a charge he is facing. Mr. Scott is still asking that I seek a personal bond from on this case, Your Honor. Although the court does see that Mr. Scott is competent, Mr. Scott does indicate that he suffers from a variety of mental health conditions. He indicates that he would love to get this situation resolved. He would love to see this prosecutor's office potentially offer him a mental health court resolution. He says that he's not going to run from this situation. He has family support. He indicates that his mental state is in a much better place now than it was at the time of this alleged event. He indicates that he has a grandmother who is involved in his life and who will help make sure he attends any and all court dates. He indicates he will go to any outpatient or inpatient treatment that the court does require. He also has no objection to being on a tether. He indicates he's willing to just address everything that's going on in his life, Your Honor, that he will not be a problem for Your Honor should the court release him. He's asking that Your Honor consider a reduction in bond or a potential personal bond. But again, I have relayed to him how serious of a charge he's facing. But I believe that's what you want me to argue. Anything else? Mr. Scott says that he's on his medication now, and he's obviously much better when he's on his medication than he is when he's off his medication, and he will stay on his medication should the court allow him an opportunity to be released. And that the nurses in the jail have upped his medication in certain areas and have him on a shot and a pill form.
Yes.
And so his mental mind frame is in a better place, and he will do anything and everything the court asks that he's asking for potential release.
I would ask that bond remain as currently set. I appreciate Mr. Fleischer's advocacy on behalf of his client. I'm struck by the, I think it was in the competency report. Mr. Scott affected a volitionally uncooperative response out during the evaluation process and attempted to feign legal knowledge, memory deficits, and symptoms of severe. Candidly, if you're uncooperative in the underlying competency evaluation, given his criminal history and the facts of this case, I believe that he is a danger to the community and as
Nothing further, Judge.
All right. I am going to deny the defendant's request for a bond reduction in this case. I think the bond is set appropriately. I would further indicate that Mr. Scott's been appearing before this court for quite some time on various matters. And typically I can let Mr. Scott out of custody, he may come back in, but usually for minor things. Mr. Scott was in custody. I took a chance, released him. He did not make it a week before this came up. Mr. Scott was arrested. So I'm not going to take that chance again, especially since this
You understand what he's saying to you?
violent case.
So, hold on, do you understand what he said to you?
So
He said that he let you out. This happened a week later.
I know, but he keeps saying the same thing.
Okay.
Saying the same thing that he's saying.
Okay. I believe Mr. Scott wants to address you directly, Your Honor, if you
go ahead, Mr. Scott.
Listen, Mr. Simpson, I know you kind of keep, going back in the past, right? But this is my life. You know what I'm saying? My grandma,
My grandma's here, my family's here. People are making me look bad. Even a competency hearing, they're making me look bad. I answered everything what I was supposed to answer the right way, and the prosecutor saying I was on I wasn't cooperating the correct way, and I was. It seems like I had to take two competency tests. And the first one, he just said what he wanted to say. I'm asking if you release me today, because I gotta go see Slay today. They said if I do get released, they're gonna follow the same recommendations you will follow if they put me on tether, if they put me in, you never put me in no classes. You never ever put me in no classes or try to do anything like that. I want my days to be filled. If I'm on tether and I have a curfew, I want my days to be filled. I be with my auntie, stuff like that. I go to classes, I go to Don Farms. You know, I need this. I need help. I have a drug problem. I never addressed it like this, but after my sister died last year, she died. She had passed away at 23. I went crazy. I didn't understand half of the things. She had heart failure. You know, it's my grandma. She's 70 years old, something like that. You know, what it happen if you keep me in here and then she just something
Mr.
happens?
Scott.
No, listen.
Mr. Scott, no, you listen. No, you listen.
But
I'm done. I let you out. I gave you a chance. I've given you numerous chances. Saying that anybody's trying to make you look bad, I don't have to go to the past. I let you out. You don't make it 8 days. And now I have you involved in a crime that involves pointing a gun at another person. I'm done.
What do you mean?
Listen,
can you just let me
motion for bond reduction denied, bond will continue.
Thank you, Judge.
But
Go to
you
Deputy.
ain't let me speak
Go
though.
to Deputy, Mr.
You ain't even let me speak.
Thank you, Judge.
Court calls the case, People versus John Terry.
Oh, Jennifer does it for the people?
Your Honor, Alexis Pluma, I'm appearing with and on behalf of Mr. Terry. Mr. Terry, could you state your full name?
John Martin Terry.
Your Honor, I do have a green sheet here. I am requesting just a 1-week adjournment. Mr. Terry did provide, or his mother provided the documentation that the people had requested in consideration for an offer. So we should be able to get the case resolved next week. And additionally, Mr. Terry would like me to address bond. I will be brief.
You'll be brief.
I will.
That'd be a change. I'll adjourn this to July 3rd, 2025, 9 a.m. Go ahead, counsel.
Your Honor, so today, Mr. Terry's mother provided proof that Mr. Terry has been participating since February of this year in medically assisted treatment through Packard Health for substance use disorder, as well as psychiatric treatment through community mental health. He would like to be released so that he can continue with that treatment. He does have a full-time job that he could go back to, and he now has reliable transportation to and from court in the form of his mother. I believe originally the warrant had been issued because he was unable to make it to his last probable cause conference date. There was also a community corrections bond violation report. He does acknowledge that he had a slip up there. It's a problem that he's working on with Packard Health, and he'd like to continue to do so out of custody. So he's asking you to consider a personal recognizance bond, Your Honor.
I'm going to deny the request for bond reduction. I don't need a response. There has been a previous violation in the past, and the defendant doesn't appear. And so I'm going to deny that request. His bond will continue. I'll set this for July 3rd, 1 week out, 2025, 9 a.m. Court does call the case, People versus Thomas Fleischer.
Eshelani for the people. Asli Bashir for Thomas Basher. Or Bashir, Thomas Bashir. Who is approaching. And Bashir, you can say.
Thomas Fisher.
Okay, all right, what are we doing?
Your Honor, I understand we reached a resolution with the people on this matter, but in order to follow the court's procedures, we're requesting the briefest possible adjournment. If it would be possible to have a 1-week adjournment on this matter.
July 3rd, 2025, 9 a.m.
Thank you, Your Honor.
Bond will continue.
Oh, sorry, and
Go
also,
ahead.
yeah, sorry.
Address, Bob.
Yeah, thank you, Your Honor. Mr. Basher has been in, or Mr. Bashir has been in custody for 38 days. I understand the basis of Mr. Bashir's alleged current bond status, his bond is denied, is based on an alleged violation that results from a police report dated April 1st. As far as I know, right now it's June 26th. As far as I know, no charges have been authorized on the basis of that report, and it hasn't resulted in a new case. I would like the court to take that into consideration. Yeah, and Mr. Bashir has also demonstrated that he presently is not a flight risk. If the court may recall, on June 17th, he appeared from a hospital bed for his hearing. He had a serious injury, but he is very serious about making it to court. The basis of this case is a non-violent felony, and I don't believe he's a danger to the community.
Counsel, this is the third time that I've had to hear this same bond argument.
Including that, well, I guess he appeared from the hospital bed at the last hearing, so that's a new thing, right? And I would note, I think the time between now and the fact that nothing has resulted even now from that report, I think is worth taking into consideration for his bond.
Response?
Your Honor, he did have a prior failure to appear in this case in February of this year. I would note it appears there are at least 2 new warrant requests under review from my office. The fact that their charges have not been issued does not mean charges won't be issued, but there are cases that are under review right now from this year, from 2025. And it appears to be in the time frame for which he did not appear before the court. I would disagree with the characterization that he's not a flight risk based on his history of failing to appear, and ask you to continue the bond for 1 week.
Set this out July 3rd, 2025, 9 a.m. Motion for bond reduction denied. Bond will. Court does call the case. People versus Gustavo Reyes.
Eshelani for the people.
Assistant Public Defender Natalie Pay on behalf of Mr. Reyes, Your Honor, who is not present. The information I received from his immigration attorney is that he's been detained. I don't have documentation of that other than what I received from that other attorney. That is my explanation for his failure to appear. I do know there was the bond violation, and I know it probably doesn't matter at this point because he's not here with us today. I do know he was previously showing up to testing and in compliance before, I believe. His stopping of testing, I believe, lines up with when he was detained.
Bench warrant 10,000, cash surety. Warrant will issue immediately.
Thank you, Your Honor.
Oh, recall. You there? Court recalls case People versus Christopher Atkins.
Brian Bowling on behalf of Mr. Atkins.
No longer there. Released to treatment yesterday.
That is accurate. That's my understanding, Judge. He is at a Salvation Army facility in the city of Detroit. He is actually scheduled to be sentenced on that Livingston County matter on July 10th at 8:30 a.m. That's the set time. It's my understanding from the point of contact I have for Mr. Atkins is that the Salvation Army program is at least a 6-month program and basically is part of what they expect the sentence to be on the Livingston County matter in their, what they call their IT court there. So ultimately, I'll leave it to the court. If you want to do the 10th, obviously I have no problem with that.
Well, except that I'd be doing it at 9. And then he's got that appearance at 8:30.
Right, yeah, no, I
And
get.
So
So if we,
why don't we do this and this way, I think you can also kind of catch up on it. I'll adjourn this to July 22nd. That's a Tuesday, so but I'll adjourn it to July 22nd, 2025, 9 a.m. So maybe we can find a way to get him to appear and see exactly what he's doing.
perfect, thanks, Rich. I do have a green form if you want it
Yes.
for the file. Thank you, Your Honor.
Thank you. Court does call the case, People versus Jamie Burke. Burke?
I apologize, Your Honor. Alexis Bloom, I'm appearing on behalf of Mr. Burke. Your Honor, I'm not sure why he hasn't made it over here. And I haven't had contact with him. The only number that I have is for his mother.
And warrant will issue for defendants to appear. Bond, 10,000. The warrant will issue.
Understood. Thank you.
Thank you. You may.
Good morning, Liliana. You're in front of the Honorable J. Cedric Simpson out of the 14A District Court, Washtenaw County, State of Michigan. We need your assistance with one matter this morning. Our number is 1423.
Is he here?
He's in custody at this time.
Okay.
Yes, thank you. I'm ready for your instructions.
Can you please raise your right hand to be sworn? Do you solemnly swear or affirm that you'll interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Spanish and from Spanish into English in a manner not before the court, so help you God?
.3 CR 951. Both the state of Texas versus Jeremy Dixon. Mr. Dixon? Yeah, present with your attorney, Mr. Vasquez, and the state's attorney. All right, the court has reviewed these files and recalls these cases. Go ahead, Mr. Vasquez.
Your Honor, it's a $1 million bond on the murder is the one I'm most concerned with, and we've asked for the bond be lowered to $150,000, given the Dixon a chance to bond out. I've spoken with family members, but none of them are here to testify. And I can pool the resources and come up with a month to sign a contract to give to Mr. Dixon out. They've spoken to some bondmen, and he did out work until his trial date, and maybe hire a lawyer of his own choosing.
How would that work? Well, you hadn't hired one yet, right?
No, sir.
Well, He says he has zero income. This was back on October 23, when he was arrested about 2 months after the murder case was filed. And he claimed zero income, and that's my writing. I wrote it, zero income according to the defendant. I was on, what's changed?
Your Honor.
Wait a second. Yeah, what's changed? You know, I mean, he's been in jail. So how can he hire somebody if he's not giving us zero income?
Well, Judge, I don't want to misrepresent anything. I'm thinking, or it's been indicated to me that the family members will try and raise him.
What's stopping them from doing that right now?
I don't know.
What else do you want to add? Because I've got some things on the record.
That's all I have.
Anything from state?
Just that the nature of these two cases, that the timeline in which they occurred makes it very clear to me that the bond is sufficient and should not be lowered.
Okay, anything you want to say?
Yes, at the time, October 2nd.
Of what year?
23. I was already incarcerated August 6th. I was arrested August 6th when I lost my job because of my arrest.
Okay. Have you been in custody ever since?
Ever since.
Yeah. Okay. So where would your income come from if you were released?
Work.
What work? What work do you have?
Well, my family has a mechanic shop.
Oh, okay. Are you good at it?
Yes, sir.
Okay. Well, how much do you get? How much do you get paid? How long did you work with it?
Well, all my life.
All your life? Oh, okay. And you are right now what? 35. Okay. And you've been working for them. You made a good income?
So,
since how long were you working for? Like when you turned 18 or something? Yeah. So about 16 or 17 years? Okay. So how much is it that you made?
I go by commission.
Sir?
You go by commission.
Okay, whatever. How much income did you have? Annually, about?
Oh, 50,000 a year.
50,000 a year? That's pretty good. I want you to send me all your income tax returns so that I can verify that. And those are on file. Get them to me so I can look at them. Okay.
I haven't filed taxes since 2021.
Get the ones you had before. Get all the tax returns that you have filed. You can get those from the IRS, copies of them. You ought to have copies.
Yeah.
Get those so I can verify that you really had an income like that.
Yeah, and I work side jobs too.
That should be on your income tax return.
Yeah, it's all on them.
Good. Then get them to me. Get copies to me. Do you understand?
I don't.
That's the first thing. The next thing is the record is going to show a couple of things. Number one, this 23 CR 951 is the first event. And this alleges that on July 2nd, 2023, you were charged with that you committed aggravated assault with a deadly weapon, a second degree felony, with the use of a deadly weapon, namely an automobile. And that was indicted, looks like 3 weeks or so after the event. And the grand jury got on that pretty quickly. When were you arrested on that case? Do you remember?
It wasn't.
You never were?
Never.
There was a warrant issued on that day, Acavius, for you.
Well, I was told the warrant was issued August 9th after I was already arrested.
It was issued the day it was handed up by the grand jury on July 26th.
And I was also told that the indictment was about hearsay and allegations.
Don't talk about that.
Yeah, but the grand jury indicted you. That's all that's important. The grand jury indicted you. They have evidence, probable cause you committed a crime, period. That's the way indictments work. It's not a debate on what the evidence was, but they handed it up. You're going to interrupt me? No, yeah. You're in trouble. You're in a lot of trouble. The worst thing is to be rude. You get the chance to speak, but don't interrupt me. It seems like that's what you do, is try to control the environment you're in. We all have a fair opportunity. Don't step on me when I'm speaking. She has to take down everything that's said. When we both speak over each other, she can't do it. When she can't do that job, the Court of Criminal Appeals, the highest court, gets upset with somebody because they say, we want to review what goes on in the courtrooms. But when everybody's speaking over each other, the court reporter can't do her job. So someone gets in trouble. It's going to be you, not me. Do you understand? Don't speak over me. That's what we learned that in first grade. Don't interrupt. You'll get a fair chance to be heard. Okay, so we have an indictment and a warrant pending on July 2nd of 2023. Then on August 6th of 2023, what's that? A month a little over a month later, it is alleged you committed the first degree felony of murder. Then a warrant comes out on that because that's indicted on August 23rd. So they indicted you about 2 weeks after this. So there are two warrants. What was the date he was arrested? And each of these involved.
Day of the murder, Judge.
Each of these allege you committed violent crimes and used a deadly weapon in each case. So those work against you. When it's an aggravated crime, when there's two aggravated crimes, you get double trouble. So what are his bonds on each of these?
50,000 and 1 million on the murder.
And this first aggravated assault, it was alleged that you drove over a human with your automobile, and they were injured because of that. The other motive, you used a firearm in the killing of another human being. Okay, the other seven. Case criminal history here. About criminal history, Mr. Vasquez, anything you want to comment on? Because that's one of the factors in setting a bond is the circumstances of the crime. And in this case, two violent crimes committed within a few weeks of each other. And aggravating offenses that are from an aggravated assault next to a murder. The court is reviewing criminal history data. And what do y'all want? Anything you want to say? Because it's poor. The criminal history is poor. Looks like the defendant was placed on deferred or unadjudicated probation on 2 cases in 2010, illegal possession of controlled substance and a theft.
That's correct, Judge.
Did he satisfactorily serve those probations?
As far as we know.
Then in 2013, he was convicted of failing to identify. That's a misdemeanor, isn't it?
Yes, sir.
And then also convicted in 2017 for eluding or fleeing a police officer. What happened on those 2 cases, please? On the controlled substance and the theft, there's F as in Frank 98069 and F as in Frank 10-9188. He was placed on deferred or unadjudicated probation on August 23rd of 2010. Did you serve those out satisfactorily? How long were those deferred? How long was the deferred? Does it show?
I believe it was 5 years.
But he's convicted in 2013 of failing to identify. I guess they didn't revoke him for that.
Yeah, that's a little.
You know anything about that?
I don't.
I think he's acting like he knows.
What? Yes.
I was let off early on probation.
Oh, they dismissed it early?
Yes.
Okay.
Well. The 09.
You can get it off. You can get dismissed in a third if you do well. A third of it. So what's a 35? 1 2/3. 1 2/3 years. So you're on deferred, and then 3 years later, you're charged with failing to identify so your probations could have ended then. Before
MTRP was filed.
Ma'am?
But an MTRP was filed.
On which case?
The 09-8069.
Yeah, the controlled substance.
But then they did early dismiss his probation in 2013, February of 2013.
What happened in the motion to revoke?
I'm assuming it was recalled in the images.
Okay. All right.
Judge, I will also point out to the court, it's not going to be in that criminal history because it was run when this was indicted. But he has a 2023 offense of discharging a firearm in a municipality that he pled to while he's been in jail.
Against Class A misdemeanor, isn't it?
Yes, sir.
Okay.
Both on together on probation, so both were dismissed on February 20th.
Do you have a driver's license? Did you have a driver's license? An active, valid one?
Yes, sir.
It was not taken away? It wasn't? You certain?
Yes, sir.
Do you know how many traffic violations that you were charged with between 2019? I'm sorry, between 2007 and 2019? That'd be 12 years. Do you know how many? Yes. I mean, sure, life, you know, but I'm looking at it.
I don't know how many, but
About how many
tickets on it.
About how many tickets would you say you got?
I've been $7,300 worth of tickets.
$7,300? No, no. How many separate offenses of operating motor vehicle irresponsible? About how many? You know, it's your life. I know how many I've gotten. Yes. Well, about when? About how many?
I don't know.
38. 38. That's
That was from the affected party.
yeah, I think it's, and also these are misdemeanors, but it's a whole bunch of them. Plus theft, disorderly conduct, illegal possessions. There's a cluster of state jails between charges in 2009, 10, and 11. Anyway, the problem is that for someone, you know, as you from youth, you have been consistent in committing crimes, and these are just getting worse. We go from traffic violations, which are Class C misdemeanors, and now you've got a first-degree felony of a murder, an aggravated assault, a second-degree felony, all within a month of each other. You pick up these, and so the aggravated nature of each of these crimes are most disturbing, and then your criminal history has gone from numerous Class C misdemeanors to now first-degree felonies. And the circumstances of the crime in each case are severe. Your criminal history, even though you're not loaded with a lot of felony convictions, it has been a consistent pattern of irresponsibility and failing to follow the rules. All right, anything else?
No, sir.
Anybody want to add anything?
No.
The court finds that the bonds are sufficient in their amount because the reasons for bonds to be set based upon the circumstances of the crime, in this case, 2 separate serious violent crimes, including a most serious murder, and those are worthy of high bonds to not only show the seriousness of these crimes, but to protect the community from further criminality of the defendant. Now, we're set for trial coming up, right?
Yes, sir.
Okay, we tried to get it last time, but this is on our radar. So are we going to try to murder or both at the same time?
Just the murder. I plan to offer extraneous evidence of the other.
Or anything else, John?
No.
All right, that is all. Thank you. Next, we got. They'll get you closer. Good. Thank you, Judge. Yes, sir. On Daniel Raleigh. Mr. Raleigh, have you talked to Tom Burbank? He's your attorney, right?
Correct, sir.
Can you call him up and find out where he is? He's 45 minutes late. We hadn't gotten a call or anything from him.
He just texted. He said, "Hardin County."
Hold on.
I said, in his office just texted.
He's in Hardin County. Why he's in Hardin County, no one knows, but he should be here.
I'm hoping to find out.
All right. We'll have to wait. Stand by. We're not going to Hardin County. He's got to come up that hill. What do you have, Captain?
I have a plea of Smallwoods.
Come on up.
Well,
I don't have it signed yet, Judge.
Yeah.
Oh, okay. Okay.
She up here.
Mr. Smallwood. That's what it's. Yes, you're gonna have to get a thumbprint with her in a minute. Yeah, stand by. They're fixing the papers. They'll just take a couple minutes. Thank you. Sorry about that, Sonny. You're good.
Yeah, I can do it again. Keep going in.
You know, get.
Straight up and down.
No, the color version document here now.
Same phone, so we're
On the lesser included,
This is
class A, so.
straight up there. She was yesterday, I finished today, so she was on board with you.
Okay, who's our attorney?
It's not, but because she had a day wrong, I couldn't get on here today, but she needed to appear.
What's, sorry.
It's additional vetting. To judge.
Can I get the file? Is that it? Thank you. So there are two cases?
Yes, sir. I'll find the file.
Mr. Smallwood, just wondering if you were asking. No, I was looking at, Miss Wilkins.
Two copies.
Mhm.
Think of in town. Finding a reference.
This is a plea on the lesser included.
Yeah, I'm looking at this, this lady right here. From probation, we're gonna need some help. Yeah. Okay, on Bandon Smallwood, yes, sir. Mr. Smallwood. Okay, we now call 25 CR 505, the state of Texas versus Bandon Smallwood, who is present with Mr. Lane, his attorney, and the state's attorney. The defendant is charged in an indictment here with the third-degree felony of assault of hospital personnel on hospital property. And let me see, there is an plea agreement. Let me look at it real quick where we're headed on this. I say misdemeanor of assault. Right?
Yes, sir.
Okay. So the defendant is going to be pleading to the lesser included Class A misdemeanor of assault, which is within the wording of the indictment where it is alleged the defendant intentionally, knowingly, and recklessly caused bodily injury to another person.
Yes, sir.
And because we're dropping the who the personnel and employee who was the victim, who has special protection under rule of law because of their job, that would have enhanced it to a 30-degree felony. So we're going to be proceeding on the lesser included Class A misdemeanor of assault, which carries with it up to 1 year in the county jail and or a fine up to $4,000. Do you understand what you're facing, sir? Sir. An agreement has been reached in your case that you would be placed on deferred or unadjudicated probation, which can be up to 2 years in length, right?
Can be, Judge.
And was there any restitution here?
No, sir.
It's up to the court's decision on the length of probation, but it would be deferred or unadjudicated probation where you would not be found guilty so long as you follow the conditions and terms of probation. If you failed, your probation could be revoked. You could then be found guilty and sentenced up to 1 year in just jail. Do you understand?
Yes, sir. And just in light of that, Your Honor, Mr. Smallwood, he is a disabled veteran with schizophrenic disabled veteran.
Is he competent?
Yes.
He wasn't acting insane at the time. He's not insane at the time.
Absolutely not.
Okay.
No.
Well,
I feel that the judge is going to do something beyond our agreement. That's all.
Like what?
Like make the term 2 years instead of 1 year deferred.
Well, that's what I can do.
You're arguing. Just trying to convince you.
But I can also shorten it.
Yes, Your Honor.
For good behavior on probation.
We have no objection to that.
Yeah, which I do it literally every day.
I know.
Every day. No. Just.
This was at
understand
Baptist
this.
Behavioral Judge.
I understand. And what I want to do in making rulings like this is the rights of the defendant are foremost because it's constitutional. On the other side of the coin, we have victims who feel like when you're caring for people who are sick, that's a most wondrous profession. We don't want people to say, I don't need this anymore, or I'm going to get kicked in the face. I agree. Like what happened here. And they're going to know from what I do that they're protected as victims and you're going to be held accountable fairly. But, they don't get paid to get punched or in this, I'm sorry, this was kicked on the right side of their face, causing them pain. They're doing you a favor. They're taking care of you. It's a most wondrous profession. I don't want people going, I don't need this because I'm not protected. All right. You have to pay. And these are wonderful professions and the people need to be taken care of. But I'm going to follow the agreement, but they're going to know, you're going to be put on probation for 2 years. You do well, I'll shorten it as a reward. Okay. And we can do it in a third of the time.
Thank you. Do you understand?
Just don't do this, please. Don't hurt people, especially people who are doing God's work by helping other humans and trying to care for them. If people said, we're not going to do this job, we're not going to do this because people kick us in the face, then what happens when you have to go to the hospital? Nobody's there. Get careful. If I follow this agreement, which is placing you on deferred or unadjudicated probation, and again, there's no restitution here, correct?
That's correct, Judge.
And this can be up to 2 years in length. If I follow this, sir, which I intend to do, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this lesser included Class A misdemeanor of assault, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
Let me show you here what's marked in State's Exhibit 1. Did you sign that document? Voluntarily? Did you understand it? Discuss it with your attorney? Or the contents all true and correct?
So,
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. Among other things, the state you are mentally competent to enter your guilty plea. It's freely and voluntarily made. The indictment's been read to you, or you've read it. You are guilty of the crime charged and any lesser included offenses like the one you're pleading guilty to, the lesser included Class A misdemeanor of assault. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true at State's, so help you God.
sir.
State's Exhibit 1 is made a part of the record for all purposes.
No objection.
Pre-sentence report's waived.
It is, Your Honor.
I'm going to follow this agreement. And on a 2-year, if he's placed on 2 years probation, we can shorten it to 1/3 of that too, right? Which is 8 months.
Yes, sir.
What I want though is also on this probation, we got to take care of certain things that put him in this situation. Do you take regular medicine or something?
Yes, sir.
You do?
Yes, sir.
Okay, you're going to have to continue to take the prescribed medication as it is prescribed. Don't fail to do that.
Yes, sir.
Was that a problem here in this case? Did you fail to take the medicine on time or something? Maybe, I don't know.
He went in to the hospital for an episode of a mental episode, and I think this all kind of sprung out.
Okay, what about is there a program for folks who have, we need to know what it is for his mental issues that he is being handled with so that we can make sure that he continues and maintains whatever assistance he's getting.
That would be the mental health case though,
I
Judge.
think she.
Okay, it's on there. We'll put him on there. Okay, good. That ought to take care of it.
Yes, sir.
But take all your medicine and make sure. Now, what happened? You get this from the military?
Yes, sir.
Were you affected? What were you doing? Were you in? Where did you go?
So Kuwait.
Kuwait.
Yes, sir.
Okay. And were you injured there?
Was injured.
Yes, sir. But it wasn't a friendly place, was it?
No, sir.
That was very dangerous. Yes, sir.
I scan people in with the wine and stuff like that.
Sir.
I scan people in with the wine, look for camera and stuff like that.
Yes, sir. But this medicine that you're taking helps you, doesn't it?
Yes, sir.
But you got
Understand.
yeah, keep doing that as prescribed. That's going to be important for your probation.
Yes, sir.
It helps you be the best you can be. Okay. I think it's in his best interest that we do as long as we can, just to help him. Because we don't want him to backslide. All right, I'm going to follow this agreement and find there is sufficient evidence supporting this agreement from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt as you are mentally competent to enter your guilty plea and it's freely and voluntarily made. But to find you guilty beyond a reasonable doubt, there's enough evidence here, but I'm not going to find you guilty. So long as you follow these terms and conditions of probation, you get another chance. It'll be for 2 years or less. And there will be terms and conditions of probation, which are normal and customary for this type of situation, including you will be completing an anger management class and also be placed on the mental health caseload. And also it goes without saying, God bless you, whatever you've been prescribed for medicine or for your medical needs, you must follow those prescription requirements and take your medicine as required. Okay. And then everything should be fine. Okay. You're going to be released here. And what are you going to do next? Do you work somewhere? Are you looking for something for employment?
Disability and SSDR. He's married, Your Honor. I've been in pretty constant contact with his wife. They were in Florida.
Living?
I believe, yes. And
they're back?
Yes. So I think they're going to have to establish another residence. And I've told them they'll have monthly reporting to Jefferson County and to wherever they're going to go permanently.
Does your wife work? Is she employed? Nobody's employed in the house?
I just received a disability.
Yes, sir. I understand, but I know a lot of people who are disabled who are, employed and do things. You would? Good. Well, don't think you can't do it. If you're capable and you want to do it, you can do anything you want. As long as it's following the rules and not hurting others. But working helps the world and helps you. It makes the world a better place by you getting involved and doing good things. And then getting paid for it. Things you like. Okay. All right. But anyway, work with your probation officer. They're very nice people and they'll help you along. Good luck. Yes, sir. Okay. Take that medicine like you're supposed to. Okay. Thanks, Mr. Smallman. Kevin, anything else on this?
No, Your Honor. Thank you.
Okay.
The process of getting person right.
Your cat.
So it's they're only going to
What are we doing today? Got to work on this a while. What are you asking?
I think when you said
Court calls the case People versus Joletta King.
Absolutely for the people. I'm sorry.
Edward Drucas for Jolita King, who is approaching. Thank you, Your Honor.
All right, what are we doing on this?
Your Honor, I'm asking for a brief adjournment. I had just sent over all the discovery to Ms. King that I need to review with her. A week or two is fine.
Probable cause conference will be adjourned July 10th, 2025, 9 a.m. or right in the case bond. Thank you. Court calls the case of the People versus Daisha Moore.
Good afternoon, Your Honor. Raymond Cook with the People.
Good afternoon, Your Honor. Christina Costantino appearing with and on behalf of Deja Moore. Ms. Moore, can you please state your name for the record?
Deja Moore.
Thank you. Judge, I have just recently been appointed on Ms. Moore's case. There is some discovery that I need to obtain, so I would be asking for an adjournment of the PCC.
Probable cause conference, July 10th, 2025, 9 a.m. Bond continued.
Thank you,
Thank
Judge.
you, Ms. Moore. Sorry about mispronouncing your name. Court calls the case People versus Emily Bates.
People. Good afternoon. Assistant Public Defender Laura Kearney on behalf of Ms. Bates. Ms. Bates on Zoom, Your Honor.
Yes, I am. Yes, hello, court. Hello, Your Honor.
Okay.
Good morning. Good day. I'm so happy I made it today.
Pardon?
Well, it would be good morning, Your Honor. Yes, I am here.
Okay. Can you turn on your camera, please, Miss Bates?
I did.
Oh, there she is. All right. Very good. She is.
Your Honor, unfortunately, I am asking for another adjournment. I know this has been before, Your Honor, multiple times. Ms. Bates, I have not been able to contact her this week. I did speak with her father, who stated she's been in the hospital for a couple of days, which probably is why we've been playing a little bit of phone tag. So there has been an offer extended. We do need to review that with her.
Got it.
Thank you. Well, I appreciate that. Hello.
Cause
morning, Your
conference.
Honor.
Good morning. July 17th, 2025, 9 a.m. or as your invite indicated. Bond will continue. All right.
Thank you. I look forward to seeing
Thank
you
you.
again, sir. Thank you very much.
All righty. Thank you, ma'am. Court does call the case of People versus Michael Frazier.
Assistant Public Defender Jay Bellinger on behalf of Michael Frazier, who appears via Zoom. Mr. Frazier, can you please state your name for the record?
Mr. Frazier, you'll have to unmute and turn on your camera.
Your Honor, I can inform the court that I am going to be asking for an adjournment on this matter. I just submitted mitigation to Ms. Douglas yesterday, and we're just waiting on her consideration.
Michael Frazier. Oh, counsel, would you be comfortable? I usually prefer to see people, but rather than pass it, I'll just adjourn it out and you'll be able to inform him.
I understand. Yes, Your Honor, I will. Thank you.
Probable cause conference, July 10th, 2025, 9 a.m.
Thank you.
On continue. Can you
Yes, I
and type that into it? We'll send him a written notification also.
Thank you.
Court calls the case People versus Taiwan Griggs.
Assistant Public Defender Chelsea Vergils with and on behalf of Taiwan Griggs.
Sound real confident, man.
I'm less
Taiwan
confident than
Griggs?
I'd like to be.
What'd you say?
But I'm less confident than I would like to be on that one.
He's not checked in. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000. Cash surety. That warrant will issue immediately. For cause case, the People versus Benjamin Hoffman.
And then on behalf of people, Your Honor.
Benjamin Hoffman.
Your Honor, they might be in the hallway. I just spoke with his attorney, so I think they're in the hallway.
Okay. Oh, wait, Miss Lowe, is it 0 or is it O? Okay, just checking. I'm just trying to make sure we get that all right. Have to state your appearance, please.
Alfred Brad on behalf of Mr. Hoffman, who's standing to my right.
Sir, state your name.
Ben Hoffman.
All right.
What's that?
Yes, you may.
Stay right there. 38586.
Thank you, sir. All right. What are we doing on this case?
Your Honor, I think we're close to resolution. I think we just need another court date for what will probably be a plea before this court.
Correct, Your Honor. And I believe the victim in this case, Ms. Hoffman, is here to request contact with the court, would like to hear from her.
Yes, I'll hear from them. They're going to need to move off. So. All right.
Good afternoon, Your Honor. I'm here to request that we,
Hold on.
I'm sorry, what was it?
I need your name.
Oh, I'm sorry. I'm Anna Hoffman. I'm the judge in this case, and I'm here to request that the no contact order be modified to allow consensual contact with the defendant for the reasons that we have 3 small children together in a home, and I need to be able to contact him for basic questions on parenting and maintaining our home.
Okay. Do the people have a position?
Your Honor, at this time, I would object. I have concerns given the nature of this case, given that it's strangulation. While I do think there are close to a resolution, at this time, I would object to just complete communication. If they wanted to do communication in writing regarding childcare, that way there's a record of it. I would leave that in the court's discretion, but at this time, as to just non-consensual contact, I would be objecting.
All right. All right. Anything else you want to tell me, ma'am?
That's it. I'm just
okay.
Hoping to have some contact. Thank you.
Okay. All right. How much more time do you guys need? Then I'll roll on to no contact.
Your Honor, 2 weeks.
Will that work for you, counsel?
Yes, Your Honor.
All right. Probable cause conference will be adjourned to July 10th, 2025, 9 a.m. or as your invite indicates. With reference to the defendant's bond and the no contact provision, at this point, I'm going to leave that in place. I'll see what the resolution is, and I'll certainly reconsider it, Ms. Hoffman, on the 10th of July. All right.
Your Honor, our understanding of what is in the file allows my client to have phone contact with the kids. They have their own cell phone. He will not contact the victim in this case, but the kids and he can have some contact relative to a couple of vacation dates they have between today and our next court date.
Yes, with reference to the kids.
Yep.
They can, the contact is not prohibited.
Thank you.
All right, it is only with Ms. Hoffman.
Yes.
It is. All right. Bond will continue. And counsel, because of the way that counsel is appointed in this case, I think initially out of the gate.
Yes, I think that a public defender was. I have a stip and order back in my office. I failed to bring it with me.
For the substitution of.
I do.
Thank you. All right, we'll just need that.
I will make sure.
All right.
Thank you, Your Honor.
Thank you. Court calls case People versus Fabian Hosmer.
Brian Bowling on behalf of Ms. Hosmer, who should be on Zoom. Your Honor, I did get a text message back that she was. Okay, good.
She's in the waiting. Shouldn't have told counsel. I wanted to see him panic. He's not in the.
Oh.
Now he panics.
Now I will panic. Can I give her a call? Did you pass it, Judge? She told me, she texted me, she was walking into work where she was going to Zoom from. I know she wants to participate today, Judge. She was just in the waiting room, apparently.
No, she wasn't. She wasn't in there, was she?
She is in the waiting room. I have admitted her, but she still hasn't joined.
Oh, she's in the waiting room. You admitted her.
But she
It's asking for her to join and she's not.
Yeah, or it's like.
Thanks, Judge.
Wanted to issue a bench warrant. Court calls the case People versus Sherry Hughes. Whoa, where'd you come from? I mean, no, that was wrong. I mean, good afternoon. I did not see you over there. Okay. Is that, no, you don't, but okay.
Assistant prosecutor is here on behalf of the people.
Mike Gaddy, First Assistant Public Defender on behalf of Ms. Hughes, who should be here via Zoom, Judge. I don't see her.
She is. Ms. Hughes? Ms. Hughes, I need you to unmute and turn on your camera, please.
Yeah, can you hear me?
I can hear you. We cannot see you.
Okay, how do I do? Hang on a second, I'm learning how to do this.
Okay, there.
Is it start my video?
You just did.
Oh, there you go.
There you go. We learned something today.
Can you see me?
Yes, we can see you. All right.
Okay.
What are we doing on this case today?
Your Honor, I'd ask for a brief adjournment. Ms. Hughes was going to get an assessment, but she came down with pink eye. I submitted a medical form with the request for Zoom.
All right. So
It should just be a couple days. She's not allowed to, be around people for contagiousness, if that's a word.
No, it isn't. Probable cause July 17th,
Thank you, Judge.
2025, 9 a.m. Bond will continue. And Ms. Hughes, feel better, please.
Yeah, July 17th?
Yes, July 17th.
Okay, thank you.
Thank you. Court calls case People versus Serrano Johnson.
Assistant Public Defender Chelsea Vergils with and on behalf of Cyrano Johnson, who approaches. Mr. Johnson, please state your name.
Cyrano Johnson.
Thank you. All right, what are we doing?
We're asking to adjourn
course
briefly
you are.
to continue a plea discussion. I know I sound like a broken record today. I apologize, Your Honor. At least I'm not addressing bond, right?
I enjoy hearing bond motions. Why are you shaking your head, Cannon? You're asking for bench warrant. Sit down. Probable cause conference, July 10th, 2025, 9 a.m. Bond will continue.
Thank you,
All
Your
right,
Honor.
thank you.
Thank you, sir.
Court calls case of the People versus Anushka King.
Good afternoon, again, Victoria Burton here, Assistant Prosecutor on behalf of the people.
Good afternoon, Your Honor. Student Attorney Kara Rosenkrantz, under supervision of First Assistant PD Michael Gabby on behalf of
Anushka King.
Good afternoon. All right, what do we do?
Your Honor, we're going to be requesting a brief adjournment. In this case, we did receive a plea form last night from the APA, but due to Attorney Apple's absence from the courtroom today, we haven't had a chance to go over it with Ms. King.
Probable cause conference, July 10th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you. Court calls case People versus Christopher Langford.
As on behalf of the people, Your Honor. Ashley Bashir on behalf of Christopher Nieper, who is approaching.
Christopher Nieper, Your Honor.
Your Honor, we're requesting an adjournment in this matter. This is there's a very involved, lengthy police report is related to this case. We are requesting additional investigation within our office and potential additional discovery. So I requested 4 to 6 weeks.
4 to what?
4 to 6 weeks, if possible.
For what reason? I guess I don't.
Well, 4 weeks then, you know, if the court will, just so that there wouldn't need to be an additional adjournment after that. And so that we could, if we could reach a resolution at this stage, we could do that without having to do that.
To the 17th, 2025, 9 a.m. or as their invite indicates, bond continue.
Thank you, Your Honor.
Thank you, Your Honor. Thank you. Court calls the case of the People versus Alexander Cronin.
Your Honor, Abigail Nice-Walker requesting permission to practice pursuant to MCR 8.120 under the.
Oh, threw your fellow intern under the bus by emphasizing that. Right. Oh, guess I don't have to say. All right, permission to practice is granted.
Good afternoon, Your Honor. Laura Yagi, Assistant Public Defender with and on behalf of Mr. Cronin. I do have, who's present on Zoom? Mr. Cronin, could you state your name for the court?
Good afternoon, Your Honor. My name is Alexander Cronin. How are you today, sir?
I'm doing well. Thank you. All right.
Your Honor, I do believe we're getting closer, but I am asking for another adjournment to continue negotiations.
Probable cause conference, July 10th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you. Court calls the case People versus Eric Coons.
Victoria Burton here, Chief Assistant Prosecutor here on behalf of the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Coons, who is approaching. Please state your name for the record, sir.
Eric Coons. Thank you.
Thank you, Your Honor. I'm respectfully requesting a very brief adjournment. I'm handing my client a discovery packet for him to review, and we are going to further discuss what he would like to do in next steps for this case.
That objection, probable cause conference, July 10th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court calls case People versus Shelby Lawson.
Christina Bear, here for the people. Stephanie Cannon on behalf of Lawson, who is appearing for right. Ms. Lawson, could you please state your name for the record?
Shelby Lawson.
Oh, and we are just adjourning this case, Your Honor, for plea negotiation, hopefully with a resolution very shy of trial. And I don't know where her grade sheet went.
July 2025, 9 a.m. or is your invited bond continue. Thank you.
July 10th.
Thank you, Your Honor. Thank you.
Case of the People versus Austin. Is it Lauderdale?
Victoria Burton here, Chief Assistant Prosecutor here on behalf of the people.
Assistant Public Defender Chelsea Vergils with and on behalf of Austin Lobestall. Please state your name.
Austin Lobestall.
Your Honor, we are asking to adjourn. There has been an offer in this case, which we appreciate. We're just asking for some time to consider that.
July 10th, 2025, 9 a.m. Bond will continue. Court does call the case of the People versus Lucas Lovely.
Good afternoon, Your Honor. Raymond Cook for the people.
Brian Bowling on behalf of Mr. Lovely. Should be on Zoom.
Hello. Hello. Do you have a camera, sir?
Yes.
Oh, there you are.
Can you state your name, Mr. Lovely?
Lucas Lovely.
Judge, we have a resolution in this matter that Mr. Lovely would like to take advantage of. He would plead guilty to 2 amended counts or added counts of attempted assaulting, resisting, or obstructing a police officer in exchange for a dismissal of criminal felony charges.
That's what the plea agreement indicates, is that he's going to be pleading guilty to an added count 3 and an added count 4 of attempted resisting and obstructing a police officer. And then counts 1 and 2 would be dismissed.
That is the people's understanding.
Okay. Which one of you gentlemen has worse writing than I do wrote this?
That would be myself, Your Honor.
Okay. All right. All right. Sir, can you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. Yes,
All
sir.
right. State your name again for the record, sir.
Lucas Lovely.
All right. Sir, it is this court's understanding that you are going to be pleading guilty to 2 charges of attempted resisting and obstructing a police officer. Those are misdemeanors punishable by up to 1 year incarceration and a $1,000 fine plus court costs. You understand that?
Yes, Your Honor.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Fleischer in the 14A3 district court. You understand that, sir?
Yes, Your Honor.
All right. And understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
All right. To the charge of attempted resisting and obstructing is contained in count 3. How do you plead?
Guilty, Your Honor.
To that same charge as contained in count 4, how do you plead?
Guilty, Your Honor.
All right. Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes.
You signed an advice of rights form, is that correct?
Pardon me?
You signed an advice of rights form?
I
Or
think
had your attorney sign it after he went through it with you?
Yes, Your Honor.
All right. Do you have any questions regarding any of those rights on that form?
No, Your Honor.
You understand that you're giving up the trial rights which are contained in paragraph 5 on that form?
Yes, Your Honor.
All right. You understand also, sir, you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation?
No, sir. No, Your Honor.
Are you on parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to these charges?
No, Your Honor.
Has anybody threatened you or coerced you in any way?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you are indeed guilty?
Yes, Your Honor.
All right. Sir, on the date of September 25th, 2023, at the location of 519 Lane Street, did you come into contact with officers from the Chelsea Police Department?
Yes, Your Honor.
And did you also come into contact with a firefighter on that day?
Yes, Your Honor.
All right. With reference to the police officers, what'd you do that makes you think that you're guilty of this offense?
I resisted arrest and.
Okay, they were trying to arrest you?
Yes, Your Honor.
All right. And in what way did you resist arrest?
Just a struggle, and then I, yep, a struggle, and then I spit on them one.
Okay, so you spit on one of the officers.
Yeah, I'm very ashamed of it too, Your Honor.
All right. And there was a firefighter or somebody from the Chelsea Fire Department there?
Yes.
And what do you do that makes you believe that you assaulted that officer and or resisted that officer or their instructions?
That's just what I don't know. I'm guilty, Your Honor.
Your Honor, may I have one here?
Please.
Mr. Lovely,
yes.
When you spat at these individuals, some of that spit got onto the firefighter, is that correct?
Yes.
Okay. So when you spit, you hit more than one officer and or firefighter?
Yes.
All right. Counsel? No, I won't ask that. Sir, I do also have to advise you that if you are placed on probation, and if I accept the plea in this case, and you commit misconduct as defined under the Michigan court rules, you would not be permitted, first of all, to withdraw your plea. You understand that, sir?
Yes, Your Honor.
And also, the judge in this case, that being Judge Fleischer, would not be bound by any particular sentence agreement or evaluation if you commit misconduct. Do you understand that, sir?
Yes, Your Honor.
Counsel, are you aware of any other promises, threats, or other inducements which caused this plea?
None from the people.
None for the defense, Judge.
All right, counsel, have I complied with the court rule, and would it be proper to accept this defendant's?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea to counts 3 and 4. Counts 1 and 2 are dismissed. A pre-sentence investigation and report is ordered at 1483 probation. Sentencing in this matter will be August 4th, 2025, 9 a.m. before Judge Fleischer. Bond will continue.
Thank you, Your Honor.
Thank you. Thank you, sir.
Thank you, Your Honor.
Court does call the case of People versus Robert David Martin.
Victoria Burke here, she was the prosecutor up here on behalf of the people.
Good afternoon, Your Honor. Councilman Mason on behalf of Mr. Robert Martin. Your Honor, at this time, we're requesting an adjournment. My client is due to get a substance abuse assessment on July 11th, so that we can submit that for an offer, Your Honor.
Your name, sir?
Robert Martin, Your Honor.
When's his assessment?
On the 11th, Your Honor.
July.
Yes, sir.
Probable cause conference then will be adjourned to July 17th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor. Thank you, Your Honor.
Court calls case of the People versus Jeremy Mazza.
Ordinance for the people.
Assistant Public Defender Natalie Pate with and on behalf of Mr. Meza, who appears via Zoom from Bear River. Sir, can you please state your name for the court?
Jeremy Meza.
Thank you, Your Honor. So as I did just state, Mr. Meza is currently in treatment at Bear River.
Yes.
I'm respectfully requesting an adjournment to give him time to both continue and complete that treatment and then hopefully provide a documentation from his treatment to the people for their consideration.
How much longer do you have to go at Bear River, sir? You know?
Probably about 75 days. That's just a guess, Your Honor.
Just a guess. All right. I got you. All right. How's it going for you?
It's going really well. The recovery is going really well.
All right. That's good to hear. All right. What I will do is, and I'll adjourn this out to August. That was the date I was using, right? I'll adjourn this out to August 7th. We'll touch base, see exactly where you are. He may not be finished at that point. Just make sure everything's on track. 9 a.m. Bond will continue in this case.
If I may, okay, if I may,
Yes, sir.
Your Honor. Afterwards, I also am going to be doing 6 months of outpatient therapy as well.
Yes.
Okay.
And usually some type of outpatient is part of that afterwards. So I realize that. I think they want to get you to a certain point and
Okay.
then look at how we can resolve the case.
All
right.
I appreciate it. Thank you, Your Honor.
All right. Thank you. You take care now.
Thank you, Your Honor. Thank you, sir.
Thank you.
Court calls case People versus Jody Merritt.
For the people.
Laura Yagi, Assistant Public Defender with and on behalf of Ms. Merritt, who is present. Ms. Merritt, can you say your name for the court? Jody Merritt. And Your Honor, I do have a green sheet regarding the PCC, but we are also here for I believe the sentence on the bond violation. Ms. Merritt did plead guilty to did plead to the bond violation several weeks ago at this point. She did, I think, at least 20 days in jail. And I'm very pleased to report I have her certificate of achievement for successful completion of the Oakdale Recovery Center. I've received no other violations for the Scram tether that she's had on since March. She did also provide me with an updated list, and she provided me with this previously, but an updated list of her meetings that she's been going to. So she's been really active in her recovery. We are asking that the court would sentence her to the time served that she did in jail. And we are asking if the court would consider changing her bond to allow her to test 3 times a day on SoberLink as opposed to the Scram. Mainly, the main reason is because she's doing well in her recovery. She's active, she's going to meetings, she completed treatment, and also she has medical issues where her legs are swelling. I know I mentioned this to the court last time. She's been having to go to these doctor's appointments. She has to go to her doctor today. And so the SoberLink will provide, it will be easier for her physically with her lower extremity swelling. And it would still ensure compliance because it would ensure that she's not drinking by having her below 3 times a day.
Any response to that from the people?
Your Honor, we would oppose any change to her bond conditions at this time. This defendant had a previous bond violation for drinking on this OWI 3rd, so we would ask that you continue the current bond conditions.
Have anything you want to say before I sentence?
Oh, no, sir.
No? What did you learn from all of this?
To be abstinence free of alcohol. So I can have a chance at life. My liver's in bad shape.
On the bond violation, I will sentence her to 21 days. Special idea credit 21 served. With reference to the request for a change in the type of testing, I'm going to leave that in place. I won't say I won't consider it at some other point, but this defendant would have to realize that given where she is with, in terms of this court, were she to miss a blow on that SoberLink, I would consider that a positive test. And then I don't think she wants that to happen. So I'll leave the Scram tether in place. How much time did you need?
Not long, Your Honor. I would ask for the soonest, maybe, I think 2 weeks. Is that? Thank you, Your Honor.
July 10th, 2025, 9 a.m.
Thanks, Your Honor.
In the case bond will continue. Thank you.
Thank you.
Oh, of course. Thank you.
Court calls the case of the people versus William Moore.
Alexander on behalf of the people, Your Honor.
Your Honor, Alexis Plumey on behalf of Mr. Moore, who's approaching. Mr. Moore, could you just say your full name?
William Lee Moore. William Lee Moore.
Thank you. And Your Honor, we are just requesting a preliminary examination.
All discovery is completed.
Yes, Your Honor.
People have their witnesses available the 8th.
We'll do our best, Your Honor.
Preliminary examination in person will be set on July 8th, 2025, 9 a.m. before Judge Valvo. Bond will continue.
Thank you.
Thank you. Court calls case of the people versus Alexis Naveen.
Ashley Lonnie for the people.
Good afternoon, Assistant Public Defender Lauren Perny on behalf of Ms. Naveen. Your Honor, can we approach?
Right. There will 9 a.m. Bond in this matter will continue. 24th is not a date. That's right. It is not. It's gonna be 22nd. I'm gonna move it to the 22nd. Thank you.
Special date, thank you.
Thank you.
All right. At that time, bond will continue. All right. Mr. Bean, take care of yourself.
Thank you, Your Honor.
Right. Court calls case People versus Kyra Newburn.
Good afternoon, Your Honor. Raymond Cook for the people.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Newburn, who is approaching. And Mr. Newburn, could you just state your full name?
Kyra Newburn.
Your Honor, Mr. Newburn would like to waive his right to a preliminary exam and proceed to the circuit court.
All right. Is that correct, sir? Yes, sir. You understand the preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it. Yes, sir. You understand you will not have that hearing and that you'll proceed to circuit court for further resolution. Yes, sir. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant bound over to circuit court on a single count.
Your Honor, as to the arraignment, we acknowledge receipt of the information and would waive its formal reading and stand mute.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
August 26, 2025 at 1:30 with Judge Simpson.
August 26, 2025, 1:30 before Judge Conkey.
Thank you.
Bond will continue. Thank you. Court calls case of the people versus John Michael Nowak.
And on behalf of the people, Your Honor.
Public Defender Chelsea Virgils with and on behalf of John Michael Nowak. Mr. Nowak, please state your name.
John Nowak.
Your Honor, I am once again asking for an adjournment. There's been an offer, but it's my understanding that the amount of restitution is still being determined. We ask for time to allow prosecution to determine that amount.
Your Honor, 2 weeks.
Okay, thank you. Probable cause conference, July 10th, 2025. 9 a.m. Bond continued.
Thank you.
Thank you. Court calls case people versus Jeremiah Palmer.
So, Your Honor, Abigail Swanger requesting permission to practice.
Really? You're not gonna do it the whole thing again, are you?
Unless you want me to, Your Honor.
Right. Sounded like she was starting again, didn't it? But she stopped in the middle. She saved herself.
Would never want to waste your time.
Only attorney in the room that feels that way. All right, go ahead.
Student attorney Kara Rosengren under the supervision of First Assistant PD Michael Gaddy on behalf of Mr. Palmer. Mr. Palmer, if you could state your name.
Jeremiah Palmer. Thank you, sir. All right, what are we doing?
Your Honor, at this time, we're requesting the court set a date for exam.
All discovery is complete.
Yes, Your Honor.
People have their witnesses available the 8th.
Our best, Your Honor.
Preliminary examination in person. July 8th, 2025, 9 a.m. before Judge Fresh Hour. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you.
Yeah, that. Here's the next one. Let's call the case People versus Ryan Patterson.
Andrew Childers appearing on behalf of Mike Gift, Assistant Public Defender on behalf of Mr. Patterson, who's here to my right. Judge, state your name, Mr. Patterson. Ryan Patterson.
And what are we doing?
Yeah, we're requesting an adjournment to do some investigation and to have a meeting about the regarding the autopsy in this matter.
The medical examiner for autopsy indicates retired Washington County, Dr. Schmidt. It's our understanding he still leaves part-time employees with this county, so we're just trying to set up a meeting facilitate that between our office and.
All right. Was there a change on the complaint somewhere?
There is an amendment.
I think an amended complaint was filed.
That's correct. There was I think there was a typographical error with the name of the victim on the initial complaint. The name of the victim is Samir Bodo, Boodoo.
Got it. And have you seen that?
I don't know if we've received it or not, but we
I
did.
believe it was entered in December, but it's not on.
I'm sure, yeah, it's probably an on-base.
All right. It appears to me, just so that you're aware, right? So it's the same complaint, just the victim's name has changed, right? And that's only one of the names, the first name.
There was I think the error would be victim's mom for some reason was typed.
Instead of, got it. All right. I don't think the defendant needs to be rearranged on that, as long as he understands the charges. We're gonna, however, we're gonna have another problem. They amended this fashion, or are they gonna have to make this count?
So.
So has that been done?
I mean, just not what you.
What I just did, okay.
Based on the original information we were given, so.
Right, right. Okay, all right. I'd agree. I think we don't need to do anything else. All right. And how much time are we gonna be looking at?
Awesome.
July, probable cause conference, July 24th, 2022. July 22nd, 2025.
Oh, okay, yeah.
It'd be that Tuesday, 9 a.m. Ron, continue. Court calls case, People versus Samuel People.
Victoria Burton Harris, assistant prosecutor on behalf of the people.
Stephanie Cannon with the Public Defender's Office, appearing on behalf of Mr. Peoples. I'm asking for an adjournment. I have a confirmation from Trinity Health that he is there and has not been medically cleared at all. So I'm just asking for, at this point, I'm sorry, Your Honor, please excuse me. I can hear you.
We have documentation that says he's there.
Yes, Your Honor. And he is in the middle of a mental health crisis, Your Honor. So when I.
Yeah,
Yes.
but I'm also trying to figure out, because he currently has a bench warrant out. It's clearly a violation of his bond. I'm gonna,
Your Honor, I'm sorry, I'm unaware of that.
there's a Northfield Township Police report from their case number 252976. From the date of June 2nd, 2025, at approximately, I think it's gonna be 8. Oh, right, it's in. Well, no, we did, because we issued. And from that report, I issued a bench warrant for him.
Okay.
From what I see, and I'm not, well, I have a feeling that the events in that report may have indeed led to the hospitalization, only because the report was written at approximately 8 o'clock on June 2nd. The note that you have from Trinity indicates that it's been hospitalized since that same.
Okay.
Okay, what?
I'm gonna have to look, I'm gonna have to get it, Your
No,
Honor.
you're gonna have to, I know.
Yeah. because-
And maybe here's what, well, we'll do this. I'm gonna leave the bench warrant outstanding, but we'll give you another date.
Okay.
Okay. And why don't been there a while. Why don't I kick it out to the 10th? And at least we can try to figure out where everything is.
Thank you.
Well, no, I'm gonna make that 17. We can try to figure out where everything is on this. All right. And so, I don't know, do you have a copy of the report?
I do,
You have a copy.
I do.
All right. So what I'll do is, I'll do this, and then Ms. Cannon, I'll have my staff make a copy of the report we have. So have it.
Thank you so much, Your Honor. I appreciate it.
Court calls case People versus Durenda, is it Krasinski?
Good afternoon, Your Honor. Raymond Cook for the people.
Asa Bashir for Durenda Przinski. My client was in the court, for most of the hearing. I'm not sure, she might have stepped out. I understand that this is the end of the docket, but I would request.
No, it's not the end of.
Oh, good. Yeah, so I would request, could we pass this matter? I just ran out in the hall to check, but she may be in the, not sure. Yeah. I spoke with her several times. Yeah. Even if it could be moved to the 2 p.m. if possible.
That's it.
Thank you, Your Honor.
I'm just gonna call it on my whim.
Understood. Thank you.
Court calls the case People versus Jalen Kendrick. Just to recall.
As in on behalf of the people. Your Honor.
As Assistant Public Defender Jay Bellinger, on behalf of, but not with Mr. Kendrick, Your Honor. I have just spoken with Mr. Kendrick on the phone as well as his grandmother. Your Honor, my understanding in talking with both of them is that he was attempting to get an Uber ride down here. However, he was not able to do so. He advises the court that he will proceed on turning, assuming he's getting the bench warrant, that he will be turning himself in no later than tomorrow morning. He understands the severity of the allegations, and so he will act accordingly.
Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of $25,000 cash surety.
Thank you, Your Honor.
That warrant will issue immediately.
Thank you.
Thank you, Your Honor.
Court calls the case People versus Fabian Hosmer.
Yeah, we are hearing for people.
Brian Bowling on behalf of Ms. Hoffman, Your Honor. Hopefully she's on Zoom.
You have her name. Ms. Hosmer? Oh, there she is. Ma'am, can you state your name, please?
Fabrienne Hosmer.
All right.
Your Honor, we're asking this matter be set for an exam. To my knowledge, all discovery is complete.
People have their witnesses available the 8th.
Be available on that. The market will not be available until July 23rd, and they will also be unavailable between August 4th and August 8th.
I would have no objection to the 23rd, Your Honor. Ms. Hosmer being out of custody.
Your Honor, I'm sorry, our victim would return on the 23rd, so.
Return where?
Until the 23rd, Your Honor.
To the 20, she's just out of town until the 23rd of July.
Yes, Your Honor.
Is that a Wednesday?
That's a Wednesday. And then set it for the 29th. Does that work?
That's fine.
Preliminary examination in this matter will be set July 29th, 2025, 9 a.m. before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
But you're welcome. That's it. That's all I see in person. You did.
We're in the interpreter, Your Honor.
You may.
Good afternoon, Mr. Jude. Thank you for being here with us today. Can you please unmute your device and raise your right hand to be sworn? Mr. Jude, you will need to unmute and then raise your right hand to be sworn. Thank you very much. Can you raise your right hand, sir? Mr. Jude, can you raise your right hand?
Yes,
Thank you,
I'm
sir.
getting you. That's my right hand.
Thank you. Do you solemnly
Thank you.
swear or affirm that you'll interpret accurately, completely, and impartially, using your best skill and judgment, and to translate from English into Mandinka and from Mandinka into English in the manner now before the courts to help you God?
Correct. I will exactly do that.
Thank you.
All right.
Thank you.
You can put your hand down, sir.
Thank
Good
you, sir.
afternoon.
Good afternoon.
The court calls the case of the People versus Abading Tambajang.
Baba Dinding Tambajang.
That's it. Yes, sir.
Right.
Stephanie Cannon, on behalf of Mr. Tambajan, who is appearing to my right, say your name for the court.
Babandin Tambajang.
My name is Baba Dinding Tambajang.
Alizenda, on behalf of the people.
Could you translate that, please, sir?
Yes, it's a loku ye nyatili molla.
Uh-huh.
Yes.
Yes.
Your Honor, we are asking that this be set for a preliminary exam.
Min la moy kante wala nyinti ko se kaitol follow jibe.
Preliminary, will the people discovery is complete? Is that correct?
Koy kaitol jibe fo aba nyamale bang.
Okay.
Your Honor, to the best of my knowledge, yes.
To nyale ngamin kalamuta.
Would the people have their witnesses available on July 8th?
Ako fo molbe la sedol soto nola le bang July karo tili say.
We'll do our best, Your Honor.
Could you translate that last portion of "we will do our best," Your Honor?
Kindly repeat, sir.
Repeat. We will do our best, Your Honor.
Benna kato dango kelale alfa bunyarimba.
Okay.
Preliminary examination will be set for July 8th, 2025 at 9 a.m. before Judge Valvo.
July karo tili sayola ñenen sangot talan kononto somanda watola e lafta kaytol minu koto bola be wol natila jojo ñin koto ay min to foten yamay.
Okay.
Okay, sir.
Bond will continue. Thank you.
Adumbe tentenna abaraka.
Okay.
Thank you, sir.
Thank you.
Thank you, abaraka.
Thank you. Thank you, Mr. Interpreter. We appreciate your help.
Thank you, Your Worship. It's my pleasure.
Is Kuzinski ready or no?
I haven't heard that she's here yet. I don't know. That was Mrs. Shear.
Who told me that she convinced me to pass it to do what?
To call her client was here. She said she had them, but then.
Okay, I'll call it up in the next block. Court stands in recess.
All rise.
One, I'll give you one. Do you? Dylan Randall Ford, 25G306475. Your name, sir? You're charged with operating while intoxicated, and you do have the right to a lawyer. Would you like a lawyer?
No, that's not.
You ever been in trouble before? Your parents were here with you before, right?
Yeah, they wait outside.
Outside where?
In the lobby right here.
Let me get you a lawyer. Why don't you go get a lawyer? We'll give you a lawyer, and they'll talk to the prosecutor for you, okay?
Yes, sir.
Good luck. Grass, George Joseph Grass III, 25G306451. Your name?
George Joseph Grass III.
You're charged with the compulsory attendance at public school, a violation of that ordinance section. You have the right to a lawyer. If you want one, I'll give you one.
Absolutely. I thought we had this all settled last time. I was about a month ago.
We'll give you a lawyer, okay? You go out in the hallway and we'll set you up. And then either way, you're coming back in front of me. Elias David Caballero, 25T644-066. Kashawn Bailey, I'd like seated over here, my right to your left. What do you have? Do you have that file? Your name, sir?
Elias David Caballero.
You're charged with trespassing. You have the right to a lawyer. Would you like one?
Yes, sir.
Okay, we'll set you up. You can go out in the hallway and you'll come back in front of me momentarily.
Your Honor, may I ask you what pro per means?
By yourself, representing yourself.
That's how you're originally,
If somebody represents themselves, we're calling, the legal term is that they're appearing in pro per. Okay? Did I answer your question?
Yes.
Okay. Keyshawn Dante Bailey, 25T6455078 and V. Name? Good afternoon. You're charged with driving while unlicensed and seatbelt violation. You have the right to a lawyer. If you want one, I'll give you one. Do you want a lawyer?
Not at the moment. I actually got another lawyer. That's not present right now.
Have you hired him?
Yeah, he's my lawyer. I always go to something.
Well, I know, but have you hired him on this case?
No, I haven't. I actually was gonna call him afterwards.
Why? Well, you should have brought him here with you. If you want, I'll give you a lawyer. I mean, I'll give you an adjournment. I'll be happy to do that, but you gotta come back with them next time now. Okay.
we'll get that.
So I won't even arraign you now. I'll just give you a new date. And you can go hire your lawyer. Lisa, what do you have for me?
July 17th at 9:45.
17th at 9:45, okay? Go down the hall, get your notice, get a hold of your lawyer, and we'll have that hearing here in 2
Never seen
weeks.
the hallway, you can talk in court, never seen the hallway.
Okay?
I'm really weird with that part.
I'm sorry. You go get your lawyer. I'm adjourning the case.
Okay.
We're gonna have an arraignment and pretrial with the lawyer that you hire on July 17th at 9:45.
Okay.
Okay?
Yeah, thank you.
Any other questions? All right, good luck. People against, Mondelli. This is Audra Lynn Mondelli, 25G 306-407 A and B. Good afternoon.
Good afternoon, Your Honor. Samuel Bennett, appearing with and on behalf of Ms. Mondelli, who stands to my right. Can you state your name, please, Judge, please?
Audra Mondelli.
All right, so this will be a no contest plea under section 771.1, correct?
That is correct.
That will be to assault and battery, of course, but not to the aiding a minor. That's going to be dismissed on motion of the prosecutor. True?
That's correct, Your Honor.
Is that what you want to do, Ms. Mondelli?
Yes, Your
If
Honor.
you plead no contest, it has the same effect as a guilty plea. I want you to understand.
Yes,
If you
Your Honor.
plead no contest under section 771.1, this will be punishable by up to $500 in fines, 90 days jail, costs, or all of those penalties. I will take your plea. I'll take it under section 771.1. I'm going to send you for a pre-sentence report when we're done. And then you will come back at a later time, comply with the terms and conditions of probation, and your case will be dismissed. Do you understand that?
Yes, Your Honor.
Did you sign an advice of rights form here today?
Yes, Your
Did
Honor.
you read it and understand it?
I did.
If you plead no contest, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, Your Honor.
Counsel, is the reason for this possibility of civil litigation?
That's correct.
You stipulate I can use the police report to establish a factual basis.
So stipulated, Your Honor.
All right, ma'am, you understand all your rights?
I do.
Any questions before I ask you how you plead?
No, Your Honor.
To the charge assault and battery, how do you plead?
No contest.
All right, I'm going to review the report. I've had that marked Peoples 1. Just give me a minute here. It seems to be lengthy. Counsel, enlighten me here. Who's Logan Miller?
My nephew, Your Honor.
I see.
So, Your Honor, the reason for the argument, the fight, was Ms. Mondelli's son, who is cousins with Logan. His mother died recently. The boy who was being beat up was talking a lot of nasty things about his deceased aunt and his mother. And the boys came to the school, and then this fight started. And Ms. Mondelli came up, and there is some information there that it sounds like she was egging him on based on what was heard. There's a little bit more to it than that, but that's what the basis is. And she did touch the other boy, not her son, but the other boy. So that's what the interview is.
Okay.
And I could approach with a video, Your Honor, but if that makes it a little simpler to try to decipher all of that.
No, that's okay.
Because the video is a lot easier to understand than out writing that report.
All right, based on my review of the report, I find there's a factual basis for the plea. Are you on probation or parole, ma'am?
No, Your Honor.
Has anybody forced you to plead no contest?
No, Your Honor.
I'm going to accept your plea of no contest, all A and B. I'm going to dismiss the aiding and abetting charge. I'm going to take it under 771.1, refer you for a pre-sentence report. So you'll go down the hall. You'll get your new court date that I'm going to announce on Zoom here momentarily, and then you'll come back across the hall to probation where you'll be interviewed, and then they'll prepare a report and recommendation, okay?
Okay.
Lisa, what do you have?
July 17th at 8:30.
Is that good with you, counsel?
That works great. You said that would be on Zoom or not on Zoom? I heard you say Zoom before. This would be in person.
I can do it one of two ways. I either want the lawyers with their clients in court or the lawyers with their clients in their office.
Okay.
Now, if your client, as an example, lived in, an hour and 10 minutes away, I'd be glad to let her appear by Zoom, but if she lives in Trenton,
I understand, right? I have to be in Farmington Hills that morning,
well, then we'll do another day.
and the next week I can try.
Okay.
July 31st at 8:30.
So 31st at 8:30?
Do we do an afternoon? Is that possible? Because I am available that
What
day.
day is the week is that, Lisa?
Thursday.
It's a Thursday when the prosecutor's here.
Oh, you know what, Judge? I just got an exam set on that afternoon, but I could do the 17th. and the-
We want to set it on Gibraltar's Day is what I want to do. What day?
They're here on the 17th and the 31st.
Okay. So you want to do the 17th at 1?
That sounds perfect, Judge. Thank you.
17th at 1 PM, okay?
Sounds great. I'll direct her to probation to show her everything is.
Have a good day. Thank you. Good luck, ma'am.
It's good to see you, Judge. Have a
You
good day.
too.
Thanks, Officer. Good.
All right. All right. York. Michael York. Michael D. York, 24B 146351. A and B and 24W835631. Mr. York, your name, sir?
Michael B. David York.
Good afternoon, Your Honor. Mike Hill Crawford representing Mr. York.
So never showed up at all on this. So for purposes of arraignment on these, how is he going to proceed?
Your Honor, my client would like to stand mute and waive formal reading of the charges.